Good afternoon and welcome to the Appellate Division First Department. Most of you know the drill. I'm going to call the calendar and ask for your requested argument time. Please ask for the time you actually need, not the time that you want, understanding that I currently have 7 hours of argument time requested. That's untenable. So please, ask for what you need, not the time that you want. Understand that the court is familiar with the facts, the record, the briefs, probably more than you wish we were. And understand that the time that I allot is for you, not for the court. So if my colleagues are so impressed with your brilliant argument that they have additional questions beyond the time I've allotted, I will allow it to continue. So, that being said, here we go. People versus Darren Casanova.
Appellate requests 6 minutes and 1 for rebuttal.
Okay.
Respondent requests 5 minutes, please, Your Honor.
6 and 1 and 5. Good Gateway versus Takar. And for the audience, this will be the first case called, okay? Okay. All right. 5 and 2 and 5. Stephanie versus Ricardo. Submitted. Adanijo versus Johnson. And you?
I request 5 minutes.
4 and 1 and 4. Jera Salazar versus 250 Park.
I'll request 5 minutes.
Okay,
Respondent, Unispace, 4 minutes, please.
okay.
Third party defendant, 4 minutes.
5 and 2, 3 and 3. People versus Garcia. Submitted. Geneva versus Black.
For appellant, 5 and 2.
Okay.
4 respondent.
5 and 1 and 5. Williams versus Mount Sinai Health System.
For appellant, 5 and 1.
5 and 1 and 5. OH 126th Street Housing versus Berkeley Insurance.
For appellant, 5 and 2.
Okay. 5 and 2 and 5. Melikov versus 66 Overlook Terrace.
Appellant 6 and 2, please.
Okay.
Respondent 5 minutes.
4 and 1 and 4. People versus Kayumov. Submitted. Ingram versus McCuller. Okay.
For respondent 5 minutes.
5 and 2 and 5. Davis versus YMCA.
7 and 3, please, Your Honor.
5 and 1 and 5. Foad versus Milton Hershey School.
For the EG appellants, Your Honor, we request 6 and 1.
For the Milton Hershey School appellants, we request 4 and 1.
Okay.
And for respondent and cross appellate for that, we request 8 and 4 or above.
All right. 4 and 1, 4 and 1, and 5 and 1. ARCPE 1 versus Public Service Mutual. Go ahead.
Your Honor, Leonard Rhodes, local counsel. I'd like to introduce Thomas Kern of the Massachusetts Bar and ask that he be permitted to deliver the appellant's argument.
Okay. As I say to every time we get this application, you are welcome, but by note of information, we've got over 100,000 attorneys in New York City, but you are welcome. Your application is granted. How much time would you like?
5 and 2, Your Honor.
Okay.
Respondent 5, Your Honor.
All right. 5 and 2 and 5. All right. People versus Alec Johnson. Submitted. Aristocrat Plastic versus Silva, submitted. Pharrell Limousine versus Macro, submitted. First case on the calendar, out of order. Both Justices David Friedman and Justice Ellen Gesmer are recused from the case, and Justice Sally Ann Scarpula is vouched in. Should there be a tie, gentlemen, we will follow the rules of the Appellate Division First Department in terms of vouching in yet another judge. Please step up. And you have 5 minutes, sir.
Thank you, Your Honor.
You may proceed.
Good afternoon, Your Honors. This case presents a somewhat unusual scenario in which not one, but two separate proceedings before two different justices of the Supreme Court proceeded through to a final judgment and the entry of judgment. Yet, years after the entry of both of those judgments, a third party, my client, Appellant Shops at New Hope, was hauled before the court under the auspices.
Counsel, you may be seated. Go ahead.
Under the supposed auspices of enforcing one or potentially both of the previously entered judgments. Now, to be clear, these judgments were entered at least 2, and in one instance, 3 years before the summary judgment motion here was granted. And the conceit that the Supreme Court relied upon was that in order to enforce its earlier judgment, it was necessary to permit the plaintiff, really upon the motion of a court-appointed receiver, to post-judgment move to amend its complaint to haul appellant before the court to force the sale of a condominium that supposedly is the object of a fraudulent conveyance action. So there is a fundamental subject matter jurisdiction defect here. It's well settled that once a case proceeds to the entry of final judgment, that's it.
How do you explain this court's decision on October 24th of 2023, where it specifically says, this is 22083rd 570 at 571, Supreme Court retained jurisdiction to enforce the judgments that were entered into this consolidated action. And we have well-settled case law that allows one to have continuing jurisdiction to enforce the judgment, and then that's what's going on here.
Agreed, Your Honor, except that there's continuing jurisdiction over existing parties. And respondent has made the argument that, well, this is law, that decision is the law of the case. That motion was brought to appoint a receiver in order to sell the real property. And admittedly, things got convoluted at trial term. But the underlying motion there was to appoint a receiver to sell the property. The decision that this court rendered on that date was not about jurisdiction. It wasn't deciding whether continuing jurisdiction over a new party. I shouldn't even say it's continuing jurisdiction. It's new jurisdiction. Continuing jurisdiction would have been fine. Of course, the parties that are before the court remain before the court for purposes of enforcing judgments. And that's what that decision really was meant to say. It should not be read, as the appellants posit, to mean that long after a judgment has been rendered, a new party can be brought in under the same index number under a motion to amend a complaint that's been fully resolved by a final judgment. So that's the most fundamental jurisdictional problem, Your Honors. There are several merit problems as well, the most important of which the court, I think, has probably seized upon in the papers. There is at least a 1/6% interest in this condominium that did belong to Saloni Thacker. It was unencumbered by any judgments. It was unencumbered by any claims at the time she made the transfer to Appellant Shops at New Hope. And Supreme Court has kind of glossed that over. It ignored that fact when it ruled that 100% of the interests were subject to sale and enforcement. And that's an important interest because really we're depriving Mrs. Thacker of her valuable property.
Do you don't represent her, do you?
No, we don't.
So then don't make her argument for her, right? You represent the person who took the property that was subject to the judgments, right?
We took it.
That were transferred at the time that the judgments were sought to be enforced.
But I think that's not precisely correct, at least for Saloni Thacker's interests. when we took all of those interests, some of those were being contested. That's true. And we're not here to argue that at the end of the day, 100% of those interests properly should have been transferred to us. But we are here to argue that at the very least, Saloni Thacker's interest, when transferred to our client, well, that was unencumbered. And we should remain with at least 1/6, if not 1/3 of the tenancy.
Is this a changed position? Because my understanding on the record is that Shops tried to claim that Simba Global Limited, the Australian company, is 100% owner. Is that a representation you made on the record? So now you're suddenly changing your tune to say, okay, we just want to carve out 1/6 Solani, the wife, who's married to the husband and who has a son who both engaged in fraud here. I'm trying to make sense of it.
So to answer your question as precisely as I can, Shops at New Hope and the Simba Global are related entities. Ultimately, Shops, and this isn't in the records, I don't want to go, it's something more for discovery, but I think we've been clear that Shops is owned by Simba, an Australian entity.
No, I understand that, but you represented that the Shops is 100% Simba. I'm using just as a defined term, whereas evidence of record had to show that the deed, when it was transferred, had handwritten notations of the Thackers each having an interest here.
So, Your Honor, actually, that handwritten notation.
By the way, arguably inadmissible, but unchallenged.
Well, it was challenged, and the Supreme Court didn't care for the challenge because the challenge came in the form of an attorney affirmation saying, the attorney who handled the deed transfer, I don't know where that notation came from. It's not mine. It's not my handwriting. It's not true. So I think that's one of the things that probably should be explored through discovery if this case moves forward.
Thank you. You'll have 2 minutes on rebuttal.
Thank you, Your Honors.
First off, to say that Shops was hauled before the court when the first time they appeared was after.
Can you bring that mic closer to you?
Okay.
Thank you.
Timeline-wise, to say Shops was, quote, hauled before the court when they first took possession by a quitclaim deed after the Thackers had been served with an order to show cause to appoint the receiver is not, it's not, they weren't really just hauled before the court. The way they present it would provide a new way to deny enforcement to any judgment, because if you're looking to appoint a receiver, you just simply transfer the property. The judgment's been entered already, and you can't add them to a case. So I don't think that's
Or you could start a new case, right?
well, you have receiver appointed that. In this case, my client had judgment liens against 5/6 of the property, a receiver against half the property, and the interest would have been, you can start another case, except the appointment of the receiver was for the prior order from
Yeah,
October
but the receiver
24th.
has a lot of powers. The receiver could, I'm not arguing that that's the right thing to do, because it seems to me that that would be a waste of time. But there could be, I think the problem was that there's clearly jurisdiction over this person and over Shops. They're arguing that it's in the wrong action. To me, that makes no difference, because you can you could easily have consolidated the two actions. So the fact that there's one action instead of two separate ones is a distinction without a difference that really shouldn't carry the day.
Okay. Well, I would also note that since the receiver controls 5/6 of the interest in the condominium, and it's not a primary residence for anyone, she is fully compensated, or whoever, Shops or Solani Thacker, will be fully compensated for that 1/6 interest. And the same way any corporate owners with 5/6 of the property could control it, the receiver should be able to control it and sell it.
So she's suffering no damage, even though this lawyer doesn't represent her, she doesn't suffer any damage.
No, she doesn't. The only difference is we have an order of sale that predates this transfer. We have the right to sell it. This is really an argument over who gets the 1/6 interest, but it shouldn't, the transaction should be set aside because it delayed us forced us to bring in another party, whether we had done it in this action or another action. And separately, I would also note that the attorney who handled the deed transfer, I don't believe Mr. Evans identifies himself as the attorney who handled the deed transfer. That attorney is identified on the deed.
Let's discuss the deed transfer. Your adversary characterized it as the court not liking the evidence they put in terms of who were the officers of shops. That evidence was an affidavit, but nothing else, right? In terms of who were the owners, officers, directors of shops. No certificate with relation to the company was submitted as evidence, correct?
No, correct. There was nothing submitted as evidence other than the draft of an attorney who I believe worked for the attorney who filed the deed, saying something without putting the documents in front of the court.
Okay.
And as for that handwritten social security numbers that was annexed to the deed, that was part of the certified copy of the deed that's on file.
And what
It's
we
now
have,
been, it's no longer public, the ability to see the socials, because they filed it publicly on the ACRES system. But the certified copy that we provided included those social security numbers listing the Thackers as the owners. Finally, it's a quitclaim deed, and the wife and mother of the two judgment debtors simply helped the judgment debtors maintain control over the property for a significant period of time since the transfer. So that's aiding in the hinder, delay, and defraud, and I think that makes her part of it. So I have nothing else unless the court has a question.
Thank you.
5-6, Your Honors. Counsel for respondents said they have a judgment lien for 5-6 of the tenancy in common interests. And this is a tenancy in common. And that means that shops, as the rightful transferee of at least that 1/6 tenancy interest, has rights here. And those rights can't be trampled by trial court. And frankly, if the law of tenancy...
What right is being transferred when the property's sold, right?
As a tenant in common, shops has a right to...
No. Once the transfer is found to be fraudulent and the property is transferred back into the estate and it's sold, and then you have whatever claim you have. You know, your claim isn't wiped away. Your rights are protected.
I think, I beg to differ, Your Honor. I say for only one reason. The property, the real property itself, should not be transferred back into the estate.
Why not?
5-6.
Why not?
5-6 of the tenancy in common interests should be transferred back into the state, because 100% of the TIC interests are not subject to the judgment lien. Only 5-6. Shops rightfully owns 1/6.
are you going to answer why not?
I'm sorry?
The question was why not?
Because the law says if I am a tenant in common, I have an undivided interest in the property.
You absolutely, at the end of the day, if you're not part of the fraud, then you get your 1/6. But that doesn't mean that the receiver can't take the property and sell it because it was fraudulently transferred and pay the person who is rightfully the owner of that.
Respectfully, Your Honor, the
Are
answer...
you suggesting that because there is a 1/6 ownership, that somehow prevents the 5/6 owners from being able to sell the property?
I am, but there's an answer.
And what is the authority for that?
The general tenancy in common law, Your Honor, the receiver...
No. Give me more than that. That doesn't answer my question. Tell me what case says that a 5/6 owner or majority owner cannot then sell property and pay the minority owner their share.
The receiver has an ability to sell its 5-6% interest to whoever it wants. And we're not saying it can't. We're not saying it can't, but that's all it owns is a 5% interest. It's not a democracy, a tenancy in common.
Thank you.
Thank you, Your Honors.
First case on the calendar, People versus Darren Casanova. You may proceed.
Good afternoon, and may it please the court, Barbara Zolot for appellant Darren Casanova. Your Honors, the police unlawfully searched Mr. Casanova's car under the MRTA and the Fourth Amendment. My adversary has said that this is not reviewable as a result of the appeal waiver. The waiver is invalid, foremost because, as the court can see on page 10 of the plea minutes, the plea court confusingly suggested that Mr. Casanova automatically forfeited his suppression arguments by pleading guilty rather than voluntarily as a result of the appeal waiver. And this conflation leads this court can't be confident as a result of this conflation that Mr. Casanova—
Doesn't the written waiver satisfy that explanation? Can't the written waiver cure the conflation?
No, Your Honor, it could not, because the only reference the court made was on page 10. Now, to the extent the written waiver said something different, now we have a conflict which would itself engender confusion and lead to Mr. Casanova, who incidentally was 20 years old, a first offender with no prior experience with New York's criminal justice system, would have
When you plead guilty, if you haven't yet had the suppression motion adjudicated, don't you waive your right to the suppression hearing?
Well, here there was a full hearing and there was a suppression ruling. So absent the appeal waiver—
Well, but so the court says on page 10, when you plead guilty, you give up certain rights, including any rights you may have to move to suppress evidence. When you're pleading guilty, you do waive any further suppression issue.
That is true. The plea court, but here, remember, the plea court here was not the hearing court. So the plea court was giving the standard sort of caution it gives, not knowing whether there was a suppression hearing or not. Mr. Casanova, who again, 20 years old, no prior experience with the criminal legal system, there's certainly an unacceptable risk that he would have understood what the court to mean was that by pleading guilty, this foreclosed him from challenging anything to do with suppression.
And quite frankly, I don't understand why the court would not have known that there was a suppression hearing, since the card that moves with a defendant would have indicated that.
Yes, it was just an unnecessarily confusing statement. It's unrealistic to think that a 20-year-old first offender, let alone any layperson, would really understand the somewhat subtle distinction between a suppression motion and an appellate brief. So that is the big ticket item here that renders this appeal waiver invalid. There are other flaws, but I could move on to the merits if the court is—
Well, this is what's on my mind now. As I understand it, your client was arrested roughly 3 weeks before the MRTA was enacted. So at the time of his arrest, the very statute that you're seeking to apply here, namely that there was no reasonable cause for the police to search his vehicle when they smelled the marijuana, et cetera, which was the whole point of that statute, even though this— So the real question is, it's your view that based on People versus Pastrana, that the post-enactment hearing, we have to consider whether this law applies to suppress the gun here, notwithstanding a pre-enactment arrest.
That is the exact question, and the answer is that the express terms of the statute apply to the hearing in this case, the hearing's findings and determinations, because the express language, the plain language, applies to criminal proceedings.
So you're not in any way suggesting retroactivity?
Correct. This isn't a retroactivity question. This is direct application of the statute to the hearing.
But the hearings apply to the conduct that was already done. How do you separate them?
Well, again, we have to look at the plain terms of the statute, which applies to the findings and determination of the hearing court. That's what the statute is directed to. And I might add that Pastrana is not controlling and completely distinguishable, because the issue there, the parties
In fact, the
were
court specifically left this issue open.
this issue, and there the parties were arguing for the first time on appeal the application of the MRTA, and the Court of Appeals said, oh, an appeal isn't a criminal proceeding. But once again, by the express plain language of the statute here, the hearing was a criminal proceeding. So
Okay, so fair enough. So again, the statute, as in your view, creates a presumption that the smell of marijuana suggests that your client had at most 3 ounces, therefore it's all kosher. Okay, fair enough. But understand that, as I understand from the record, the suppression hearing judge analyzed the totality of factors. A legitimate stop because of the headlights, no license and registration, resistance to getting out of the car when they ask him politely, step out of the car under the circumstances, an attempt to negotiate that arrest by saying, okay, I'll give you my stash or something to that effect. Don't quote me on that. But the totality of all those, particularly the resistance to get out of the car, suggests a reasonable basis, despite the frisk outside the car, to search in the car. Now, based on our case law and the totality of circumstances, as my colleague pointed out, looking to the conduct at the time of the arrest, why shouldn't that search be lawful?
Okay, well, there's the MRTA reason, and then there's the Fourth Amendment reason. I'd like to, my time is up.
Go ahead.
Okay. Those things, and particularly the resistance that Your Honor mentioned, doesn't take it out of the ambit of the MRTA, really, because if it did, it would subvert the whole purpose of the MRTA and make it very easy to circumvent. Let me explain. Walcott here said they were ordered out of the car because of the smell of marijuana. So that's what he's testified to clearly. They were ordered out of the car because of the smell of marijuana. So if we use Mr. Casanova's reaction to that conduct of ordering them out because of the smell in order to create the probable cause, it would effectively be bootstrapping the forbidden smell of marijuana that the MRTA was concerned with to then justify the very searches that the MRTA was trying to prevent. I mean, that's just on the resistance piece. But what Your Honor has brought up, this totality, then brings us to, well, look, the search still has to comply with the Fourth Amendment. And I just want to briefly say that nothing that Your Honor cited, none of those circumstances provided probable cause to believe that Mr. Casanova had committed a crime which would have involved possession of a really substantial amount of marijuana. I mean, 3 ounces is not, a joint. It's a lot of marijuana. So it would have required probable cause to believe that he didn't have a license, and his 20-year-old is trying to barter his way out of having to get out of the car. And he said he had smoked earlier in the day, totally consistent with personal use, and said, here's let me give you the stash. Again, reasonable inference, the stash relates to the personal use. That all of that somehow gives the police probable cause to believe that this 20-year-old kid has more than 3 ounces of marijuana. They don't see anything trafficking like. They don't see scales, they don't see currency, they don't see baggies, they don't even talk about how strong the smell was. So given the totality, the hearing court drew the wrong conclusion. You can't conclude from those things that this kid had more than 3 ounces of marijuana, or in other words, had more than personal use amount.
Thank you.
Thank you.
Good afternoon, Your Honors. ADA Josh Weiss for the Office of Darcel D. Clark.
So how do you defend a waiver of the right to appeal?
Yes, Your Honor. I think it's important to put this plea in context. There's absolutely no indication that the court's statement on page 9 was a misrepresentation. This plea was part of a global disposition that, in addition to resolving this case,
But the colloquy from the court was not entirely accurate. Counsel's points are well taken.
Right, Your Honor. Well, the court was addressing all three cases at once, and to the extent that that comment did engender some confusion, the written waiver clearly stated that defendant was giving up his right to seek review of any suppression issue litigated in his case. And the case law makes clear that written waivers can suffice to eliminate ambiguities that arise during the oral colloquy. So we would submit that the waiver is valid.
All right, if I disagree with you because we have case law on this specific point of not drawing the distinction appropriately, what would you say then?
I would say that that one misstatement would not be dispositive. This was a thorough oral colloquy that, by and large, did track the model colloquy. Defendant confirmed that he discussed the waiver with
Let
counsel.
me ask the question another way.
Sure.
Assuming I think that there's a problem with this waiver, why should I set that aside and allow this plea to go forward in the way that it has and not address the substantive issue being posed by defendant's counsel?
Again, Your Honor, we would maintain that this waiver fully comports with.
Can you speak to the arguments regarding the MRTA and applying it to a hearing that occurred after the law was enacted?
Sure, Your Honor. We recognize that the facts of Pastrana are distinguishable in as much as the suppression hearing occurred after the effective date, but the way that the court framed its holding, it squarely encompasses this situation. And if I may, I would just like to read a sentence from the opinion. The opinion states that nothing in the text or the legislative history of the MRTA requires or supports the conclusion that the legislature intended for newly enacted 22205 to apply retroactively to invalidate searches that were conducted before the effective date of the statute.
Well, your adversary is talking not about the searches, but somehow divesting the search from the search to the hearing. So the hearing portion of it occurred after MRTA was already enacted.
That is correct. That is correct, Your Honor. But I think Pastrana is clear that the court is unwilling to disturb stops that were conducted in reliance on existing
I'm sorry,
law.
that's not what Pastrana said. In fact, Pastrana said that that issue was not being resolved by the decision in that case, that it left open that issue because that was not the issue before the court. So I disagree with you completely when you try to say that that decision somehow forecasted that it would be okay. I think the opposite. So explain to me why I'm wrong about thinking the opposite. The court seemed to suggest that there would be a different calculation and a different result.
Sure. Because
for a hearing post-enactment.
Absolutely, Your Honor. The reason is because this contingency that suppression issues would be litigated after the date of the arrest was too foreseeable to have been overlooked by the legislature. The legislature plainly understood that defendants would not be litigating
I agree with you.
motions.
And the language, tell me what in the language of the statute would allow your side to be victorious here, right? Because the statute is very clear. And it doesn't carve out stops that happen pre the hearing. It doesn't carve it out. You're making the opposite argument.
Correct, Your Honor.
Statute says what it says.
Correct, Your Honor. We would argue that the statute and Pastrana do not provide a carve out for post-enactment suppression hearings. That the holding in Pastrana encompasses all pre-enactment stops.
No, again, the decision very clearly said we are not deciding that issue. Very clearly. If they wanted to, if they agreed with you that this would fall under the same analysis, they would have been able to say so.
Your Honor,
and dispense with all of this litigation that is incurring now.
Your Honor is correct. That issue was not expressly decided, but I would note that qualifier was contained in a footnote by the dissenting judge, not the majority. The majority did not indicate that they would go the other way. I see my red light is on. Regarding the lawfulness of the stop under existing law, we recognize this is a very close call, but we would submit that the combination of consciousness of guilt evidence together with the other factors indicative of marijuana possession provided factual support for the court's finding that the officers had.
Counsel, before you sit down, with regard to the statute, where the legislators intended for it to apply retroactively, they created and specifically stated that, right? So, for example, certain convictions were permitted to be vacated retroactively, and the statute carved out those provisions, correct?
Correct, Your Honor. And if the legislature wanted different treatments at post-enactment hearings, it would have specified that intention.
And it in fact did, right?
It did in certain contexts, but not in this one. Not as it relates to not pre-enactment searches where the hearing follows the effective date.
Right, that was not specifically carved out.
Correct, Your Honor. Thank you.
Thank you. Since it wasn't specifically carved out, are we left just with the actual text of the statute to guide us?
We have the plain language of the statute, which is the clearest evidence of what the legislature intended, and it's not inconsistent with the remedial purpose of the statute. With respect to Pastrana and my adversary's reference to the retroactive effect, in Pastrana, it would have had to be a retroactive application because the appeal wasn't a criminal proceeding covered by the language of the statute. So if you're going to reach back to the pre-enactment hearing with a pre-enactment search, yeah, then you'd be in retroactivity land. That's why Pastrana made that comment. But here we have the best that you could possibly have, which is plain express language that says this applies to criminal proceedings, including under Section 71020, and in a pending criminal action, and that's exactly what the hearing was here.
But it would in effect be retroactive because the conduct that is at issue for the hearing has already happened before the enactment of the legislation.
Again, it's the particular wording of the statute which is directed to the findings or determinations of the hearing court. I mean, that's what it's...
But those findings and determinations relate to conduct that occurred prior to the enactment of the statute.
But there's nothing absurd about doing that because of the remedial purpose of the statute is to curb this kind of police conduct. So it's not inconsistent with the purpose of the statute to say hearings that take place after the MRTA that are considering conduct beforehand, we want this policy to prevail. And you know, my adversaries talked about the deterrent effect, but New York State has rejected the good faith exception. There are times when, even though deterrence may not be directly at issue, we apply the exclusionary rule because the interests at stake are that important. Thank you.
Thank you. Adanijo versus Johnson. You may proceed, sir. You have 4 minutes. Yes?
4 minutes. 4 and 2?
4 and 1.
4 and 1. So, this is a case of egregious and conscience-shocking premarital and marital fault, associated also with numerous errors, abuses, and manifest abuse of discretion on the part of the New York County Supreme Court in the matrimonial part, IAS. The issues here are, in many parts, issues of first impression, particularly with DRL 254 and that process, and also with the difficulties that the matrimonial division has in dealing with interspousal torts. I'm very much aware Xiaoyang Chen versus Fisher and the predilection of the New York courts to want to separate torts from matrimonial equitable actions. However, there are numerous instances, particularly in my instance, where the torts are entirely conditioned upon the fact of who the tortfeasor was. In this case, the tortfeasor was always Mr. Adanijo. Now, to speak about jurisdictional issues, the matrimonial court is headed up by a Supreme Court justice who is plenary potential. In other words, the current practice in the Supreme Court is for the matrimonial judges to take care of matrimonial actions. But if there are tort actions that need to be severed, then the current practice, as far as I understand it, and I alluded to this in my brief, is that a plenary proceeding would be developed, and those actions that are inconvenient or not really suitable would be carved off into the plenary proceeding, but that proceeding would again be adjudicated by the same judges in the matrimonial proceeding. That's my understanding of it. And I cited a case in which one judge sent what were essentially commercial torts over to the commercial division from the matrimonial division, and they were sent right back to the same court. On the issue of 254, there has been really no case law developed in this since 2001, when the statute was first enacted. I have been very badly injured in this. Opposing counsel did not serve me with the papers before coming to court and obtaining the 254 order. The order was adjudicated in the ex parte office by Justice Lawrence Love, who failed to note that the original pleading, the summons and notice under DRL 170.7, did not ask for any ancillaries. It was a straight no-fault allegation, which in this state, according to Palermo and Inri Pariselli, is an allegation that there literally was no fault. But then the affidavit submitted with the application claimed all kinds of domestic abuse. Now, I have to say, I might be a bit of a demanding boss when I'm controlling a company that I own and asking the other people to work with me on the goals of the company, but I am a pussycat in my private life. These allegations made by Mr. Adanijo against me are not only false, they are knowingly false, they are premeditated allegations, and Mr. Adanijo even admitted to that. Should I continue?
I'll give you time on rebuttal, okay?
I'm sorry?
On rebuttal, you'll have more time. You may proceed.
May it please the court. Morgan Williams, Milbank LLP for Plaintiff Respondent Sahid Adanijo. Your Honors, this is the latest chapter in Mr. Johnson's attempts to needlessly prolong this litigation, which is an uncontested divorce, by filing frivolous motions and appeals. All of the interlocutory orders before this court, including the confidentiality order that Mr. Johnson just referenced, are procedurally barred because they do not affect the final judgment of divorce. Additionally, Mr. Johnson cannot establish that even if these are not procedurally barred, that they affect the final judgment of divorce. Once the final judgment of divorce has been entered, there is no longer a right to appeal from these interlocutory orders. Therefore, Your Honors, there is no basis to reverse the judgment of divorce or the interlocutory orders. I'll begin first on the procedural grounds. Mr. Johnson, by my count, has appealed 10 interlocutory orders, none of which affect the final judgment of divorce. These are all procedurally barred because under New York state law, unless an interlocutory order will necessarily affect the final judgment of divorce, once the judgment of divorce is entered, there is no longer a leave to appeal from these interlocutory orders. I would also like to note that MSO4 and MSO5, which Mr. Johnson appeals, is an earlier appeal to this court that has been abandoned. Mr. Johnson appealed this order. The deadline to perfect the appeal was extended twice. He then sought to reinstate the appeal, and he then again missed the deadline to perfect. Therefore, this is also not reviewable on appeal. Unless your honors have any questions on the procedure, I'll move to the merits of the first and second amended answer and counterclaims. MSO5 and MSO8 are the amended answers and counterclaims. Mr. Johnson first filed his answer in 2020. Judge Sattler below stated that it was impossible to determine the number of counterclaims he was asserting and that the answer was rambling. She suggested that he contact the Office of Self-Represented. In his first amended answer, which is an amended pleading, and leave to file an amended pleading is only granted at the discretion of the trial court. Justice Waterman Marshall noted that the claims were nearly 3 times as long as the initial pleading, which, as I've noted, was already characterized as rambling. Many of the claims were regurgitated, and many of the claims, including the claim that Mr. Johnson already alluded to, the IIED between spouses claim, is not recognized by New York law. There was no basis whatsoever in law or fact for this pleading to be granted. Your honors, nearly the exact same thing happened with the second amended pleading. Mr. Johnson filed a pleading that was almost as long as the second amended pleading. Justice Waterman Marshall below issued a 2-page decision with case law stating that these were either repackaged claims that were barred and precluded by collateral estoppel, or that they were not pled with particularity. For instance, Mr. Johnson pled many claims of business torts against our client. Those can be severed by the trial court at its discretion, but they do not need to be severed. Mr. Johnson also made similar arguments to the first amended answer and counterclaims with regard to his answer, and Justice Waterman Marshall did not find that there was any basis to allow leave to file the second amended answer and counterclaims. Thank you.
You have 1 minute on rebuttal.
Thank you, Your Honor. Oh, sorry. On the issue of the harassment and these other 8 issues, including the 254, all of these actually have an effect on the judgment. And because there was an interlocutory appeal on at least MSO4 and MSO5, these were subsumed in the final judgment, and it is my contention that certainly the motion to recuse MSO6, the 254 issue, certainly MSO8 having to do with the second amended answer and counterclaims, these are subsumed in the judgment. The earlier appeal was not abandoned. This court has already determined that the notice of appeal extended to January 1st was a premature notice. In fact, when there is...
Finish your sentence, please.
Let me just move to one more thing. I've contested the Weicker rule. That's pretty much laid out in my pleadings. It's important to note that the Weicker case and the Baumann case involved 3 litigants, not the 2 that are normal in today's world of matrimonial pleadings. Okay? There's no way that any justice in the state would allow an amatory tort. Weicker was about an amatory tort, hiding as essentially an IIED claim. My claim sounds in IIED exactly against Mr. Adanijo and only Mr. Adanijo. As far as the assignments, these are my personal claims under Taylor versus Sturgill, as I've said in my brief.
Thank you so much. Gerard Salazar versus 250 Park. You may proceed.
Thank you, Your Honor. Good afternoon, Jillian Rosen for the plaintiff appellant. In this case, the trial court properly held that plaintiff met their prima facie showing that defendants violated the labor law. In fact, there's 2 violations: failure to secure the pipe, failure to secure the ladder. The court erred in finding that the defendant raised issues of fact with regard to recalcitrant worker and sole proximate cause. Here, the plaintiff can't be recalcitrant for 2 reasons. Number 1, there was no safety devices provided. So under this court's long case law and the Court of Appeals case of Stolt, where there's no safety device provided, the recalcitrant worker defense isn't available. Here, the pipe was unsecured and the ladder was unsecured. So there was no other safety devices was provided. This is undisputed. In addition, the plaintiff never refused to use a particular provided safety device. So it wasn't a situation, and he never ignored an instruction such that his conduct would be the sole proximate cause. At best, Pagway, who's the foreman, only gave, at best, it's a standing order to avoid cutting the pipe in an unsafe manner, which is not a sufficient substitute for providing a worker with a safety device to complete his work safely.
What about the order with regard to where to place the ladder?
With regard to where to place the ladder, 2 things. First is that there's no evidence that he placed it under the pipe. In fact, the plaintiff's testimony that he placed it next to the pipe and the side of the pipe is corroborated by Mr. Palagucci, who said the ladder was, this is at 1271 of the record, that it was not underneath the pipe, it was to the side of the pipe. In addition, Pagway admittedly didn't see the position of the ladder, and neither did Mr. Sanderson, who was allegedly 40 feet away. So we have no evidence that it was placed underneath. At most, it would be comparative fault because, again, plaintiff cannot be the sole proximate cause under Blake and its progeny if there is a statutory violation. Here we have 2. So with regard to the placement of the ladder, it doesn't support a recalcitrant worker or sole proximate cause defense. With regard to cutting the pipe, there was never an instruction. There was an instruction to cut the pipe 8 to 10 feet to protect the floor.
Didn't he also say, or whatever you're comfortable with?
Thank you.
So once you say, or whatever you're comfortable with, now you can never be found to have violated an instruction that gave you freedom to choose.
That's the discretion which this court has held. It cannot be recalcitrant if you, right, it's discretionary. But what I think is really interesting, if you look at the record, that Mr. Pagway, the instructions were, place the ladder, secure it safely, make sure the tube doesn't fall on you. Well, that's not an instruction. That's at 1160 of the record. The next instruction was, cut the pipes in small pieces to protect the floor, as I said, or whatever you're comfortable with, 1134 of the record. The thing that's really telling is at 1170 of the record, when he was asked, what'd you tell Mr. Salazar and his 2 coworkers? Well, they know what to do. All I have to do is tell them from where to cut. That's at 1170 of the record. So there was no instruction. As I say, at best, this is a standing order to, to proceed in a safe manner, which is insufficient.
Counsel, was this demolition work for which no safety device was required?
I'm sorry?
Was this demolition work for which no safety equipment was required?
Yes, of course. I mean, this was, he was on an 8-foot A-frame ladder, and there was a ginormous pipe that needed to be secured for purposes of the undertaking, because remember, he wasn't removing, I mean, the defendant's going to argue, well, it was contrary to the purpose of the work under Salazar. I distinguished Salazar in the brief. I can get to it on reply. But here, he was removing the pipe in pieces. So he was removing the hangers first, and then the defendant improperly was using a coworker as a safety device to hold the pipe, which under this court's case law, a person is not a safety device for purposes of 240. So there was of course, this pipe required securing for purposes of the undertaking, and there was no safety device for the pipe to control the descent. Again, with falling worker, the risk to be guarded against is the unchecked or the potential unchecked or insufficient checking of the falling object. So under Under this court's case law, there was no recalcitrant worker defense, and plaintiff can't be the sole proximate cause under Blake. And I can reserve anything else for rebuttal. Thank you.
Good afternoon. May it please the court. Michael Cassell for defendant respondent Unispace. As the lower court properly found in this case, there's questions of fact as to whether or not the plaintiff was either a recalcitrant worker or a sole proximate cause.
Recalcitrant on what?
What instruction are you claiming that the plaintiff violated?
Sure. The instructions that we claim he violated are: number one, we set forth the affidavit of his foreman that says he was told that day, that very day, that the ladder should not be placed directly underneath the pipe.
And what evidence is there that it was?
Well, the foreman says, Pagway says that based upon the way the accident occurred, the placement of the ladder was underneath the pipe and it fell on it.
That's not evidence, that's speculation. What's evidence? Direct evidence of someone who can say, I saw that pipe fall and the ladder was right underneath the pipe. Who said that in this record?
I don't know anybody who said that in the record.
Nobody said that in this record.
Yet his cousin or some relative that was your friend made reference to another co-worker who testified that the ladder was not under the pipe, but was exactly where the plaintiff in his deposition said it was, about a foot away from the pipe. He was facing the pipe so that he could take the Sawzall and reach up, but it was clearly not under the pipe. So you have nothing on this record, as my colleague pointed out, that would put this ladder squarely under the pipe.
There was testimony, I think you're referring to Palagucci, but Palagucci also said that what the plaintiff was cutting was approximately a 50-foot long pipe. So, keep in mind.
So you have this pipe that's being cut and the pipe ultimately falls. Was there no obligation to do something to secure this pipe? And what's the safety device for this potentially falling pipe?
Well, it is demolition work. So the intent of the work is to make sure the pipe falls to the ground.
Yes, but it has to fall to the ground without injuring its workers. So tell us, as my colleague just asked you, what safety device was provided to this worker to prevent this heavy, long pipe that had to be cut and released from a ceiling? What safety device was he provided to prevent that pipe from hitting his ladder?
Well, the length of the pipe should have been less because the plaintiff should have followed the rule not to cut a 30 to 50-foot long pipe.
What safety device was he provided to prevent this pipe from hitting his ladder?
Two things, Your Honor.
If it
One,
was 8 feet, you'd still have a problem, wouldn't you? I mean, you point to its size, but if it was 8 feet, you also have to do something to secure this potentially falling pipe.
sure, I mean, the way.
What device did you have for that?
The manner it was supposed to be done was the co-workers, there was 3 workers tasked with removing the pipe at the time of the accident.
So are you claiming that another worker is a safety device? That's not what our cases say, does it?
Another worker cannot be a safety device to the extent the cases, if you read
In fact, we've
cases,
specifically said it can't, that another worker can't be a safety device, correct?
can't be a safety device to the extent there's case law out there, for example, that a coworker is supposedly tasked with holding a ladder. Here, there's no question that that the plaintiff was provided with all the appropriate safety devices.
What?
As
We
far as the
keep
ladder.
asking you, and you have not said one word about what safety device was provided. So tell me, one word, what safety device was provided?
For the pipe itself?
Counsel, this isn't a trick question.
No, I understand, Your Honor,
okay?
of course.
So what safety device was provided?
The ladder for the plaintiff and for
A
the
ladder in our case law is not a safety device. Try again. What safety device was he provided to do this work?
As far as the removal of the pipe itself, it was the coworkers.
It was what?
The removal of the pipe. The pipe itself was the 2 coworkers.
So based on this record, as I understood it, historically, they were 2-man teams, so that if just bear with me. As I understand it, you can correct me, but there were 2 people. One would be on one end to hold it if it fell off after you cut the hanger, and the other one would cut it, and then they both would lower it down. But my understanding of the record, and again, it's not critical to this analysis, is that Pagway allegedly told them that they had to move this thing along, and they could only have one man doing the particular task and not have two-man teams, which created the conundrum. Because if we carry it the way you want to say it, the coworkers should have been there, but they were told not to, and to get the work done, and they were spread out. Hence, the problem here, because there was no safety device to cover for the second person that should have been there to catch the falling other end of the pipe here. And that's the problem we have here.
I understand all that, Your Honor.
And given all that, sir, I'm still waiting for your answer to a question posed as to how he violated the rule to become a recalcitrant worker or the sole proximate cause of this accident. I don't see that here.
I would just say this, it's a summary judgment motion. All the facts have to be interpreted light most favorable to my client, which the lower court did. There's question of fact, it's a placement of ladder, whether he cut a piece that was too long, whether the plaintiff possibly caused this accident. So I ask the decision to be affirmed.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Douglas Rosenzweig. I represent the third-party defendant, the plaintiff's employer. One of the things I think that's clear by this oral argument is the plethora of questions of fact that exist about how this accident occurred. How long was the pipe? Where was the ladder?
But not
And yet,
any of those.
yeah, go ahead.
There may be lots of questions, but none of those go to whether or not the plaintiff was provided a safety device. And if he wasn't provided a safety device, then exactly what the length of the pipe was or other questions may be questions, but they're not relevant questions.
To the issue of, there is no recalcitrant worker applicable where there has been no safety device provided. So I ask again, what was the safety device provided that would allow this court to even entertain the argument that the plaintiff was a recalcitrant worker?
There was a defect-free ladder provided to the plaintiff and the expert engineer.
That is not a safety device.
The expert engineer who testified and submitted an affidavit in connection with this case said that this was a safe way to perform the work. Mr. Padway—
Counsel, stop. My question is very clear. What was the safety device provided to this worker that would allow us to even consider the argument you are posing of a recalcitrant worker? It doesn't exist unless you've provided a safety device.
Right.
So what is the safety device?
Based on the testimony of all the witnesses, the defect-free ladder was provided.
That's not a safety device.
There was a similar case, the Mora case, that was cited by plaintiff in their brief, and the court came to the conclusion in that case that summary judgment was proper because the very same evidence that we're presenting was in an unsworn, inadmissible form. In that case, had there been admissible evidence like there is here, an affidavit from Mr. Padway, deposition testimony
Who
from
didn't
Mr.
see
Padway,
where the, I don't understand, because the testimony of Mr. Padway doesn't help you.
Right. But it's
He
for the
doesn't
jury-
see the accident. He doesn't see the placement of the ladder.
It's for the jury to determine whether a safety device was provided.
It's for us to determine whether the issue below was decided correctly. And so again, I ask you, a defective free ladder is not a safety device. So what is the safety device that allows this court to consider your argument?
The totality of the circumstances given Mr. Padway's instructions that morning to the crew not to put the ladder underneath the pipe. He came twice and saw Mr. Salazar under the pipe, warned him not to do it. He has the personal responsibility to follow the rules and instructions of his foreman that day. This was not complicated or difficult work. If you put a ladder under a pipe and you saw the pipe down and the pipe hits the ladder, that's the responsibility of the plaintiff. It makes him a recalcitrant worker, and there's a question of fact about whether that statute should apply.
Thank you.
You have any questions?
Could you address counsel's argument that that there is evidence that plaintiff, notwithstanding the instructions of his foreman, put his ladder directly under the pipe?
There's no evidence that he did. We have Padway who doesn't see it. We have Sanderson who doesn't see the position of the ladder. Plaintiff said several times, I did not place my ladder under the pipe. And then we have Mr. Palagucci, who's standing next to the plaintiff, who, by the way, is pretty unbiased, considering the wife is the cousin of the owner of the company. And he testifies the ladder is
2 feet.
approximately 2 feet away. And so there isn't any evidence that this ladder was placed under the pipe
At least at the time of the accident.
at the time of the accident. Whatever happened prior thereto is absolutely irrelevant to today, as we know. If you have no further questions, I'll rest on the brief.
Thank you.
Thank you for your time.
Geneva versus Black. You may proceed.
Good afternoon, Stephen Bergstein for the plaintiff appellant. There's 2 points I want to emphasize today. One, plaintiff seeks to void a release so she can pursue a claim under the Gender Motivated Violence Act based on a continuing duress theory. And 2,
Counsel, I need to understand something. What is the basis factually for continual duress? We've read the brief, we know the record, so let's cut to the chase. At the time of the NDA, she agreed to get a gift of a $1 million loan waiver and $100,000 a month, which she took for about 5 years. So she basically was paid $9 million as consideration for this NDA to keep silent on the behavior of the defendant before the signing of the NDA. So against that backdrop, there was no repudiation. As I understand on this record, there was absolutely no communication at all between the plaintiff and the defendant from the signing of the NDA, I guess, until now, that I'm aware of on this record. So where is the basis for continual duress?
for as long as he's sending her money, she has to keep quiet, or else he will live up to the threat he made to her when she signed the NDA. And this is a 3211 case. And he told her, if you don't take the money, I will put you in prison, I will destroy your life, horrible things will happen to you or your child. Then he sends these checks. As long as he's sending these checks, and she keeps quiet, nothing will happen to her. She speaks up, the money stops coming in. The continuing duress is, keep taking my money or else.
So the duress are the checks?
The duress is originated when she signed the NDA.
But how is it continuing?
Because he kept sending money. If you don't take my money, I'll put you in prison. He keeps sending money, I guess, into perpetuity until something happens. But for as long as he's sending her checks, it's
So apparently that something was the tweet.
correct. And then the money stopped. So as long as
So at the point that she sends the tweet, she apparently no longer feels the duress because she sends this tweet.
Well, that's an issue for the jury because she probably still feels duress, but she felt strongly enough about what he said, about his personal behavior and his righteousness, that she had no choice but to speak up. Now she's putting herself at risk, but she felt compelled to do so because she's not going to take this
So for the
sitting down.
years that the checks were coming, checks, i.e. duress, there was no contact between the individuals.
Other than sending the checks. But
So
he
the
certainly
only
knew
contact were the checks.
The contacts was every month a check comes in the mail. This is a reminder, take this money or else. Remember what I said the day you signed the NDA.
Did the checks have that in the memo part? Remember what I said?
I don't-
So $1.2 million a year for 5 years is the basis of her allegation that she was the subject of ongoing duress.
Keep taking my money or else.
Which came to 9 million. The rest was the
9.5, I think.
Right. And if there's a concern, if there's an, you know what, if there's an unjust enrichment defense, he can make an unjust enrichment defense and get the money back. But it doesn't prevent her from showing that she signed the release under duress.
So that's the sole issue. So I want to just frame the issue precisely. The NDA itself is not an issue. It's the circumstances leading to the signing of the NDA. We don't have a problem with the NDA per se, but it's how he made her do it. Is that a fair statement?
Generally, yes. It's the duress he put her under when she signed it. Sign this or else. That's the initial duress. The continuing duress, as we've discussed, is as long as the checks keep coming, keep your mouth shut or else.
Counsel, I have a different question. As to the language of the release itself, paragraph 1 states, and I'm going to cut out some of the language in between, that your client releases and discharges Mr. Black from all matters whatsoever arising prior to the signing of this agreement, contemporaneous with the signing of this agreement, or at any time in the future. How did she understand that provision?
I know what you're referring to. I'm just looking for it to have it in front of me. It's been handed to me. Yeah, she's waiving all claims at any time in the future. Okay, that I think goes to the defamation argument, right? There's a body of law in New York that you cannot waive future claims unless the future claims were contemplated at the time you signed.
So if he sexually abused her after this NDA was signed, that NDA wouldn't preclude her from going to the authorities.
Maybe he would argue that it would, but it shouldn't. It shouldn't. The question is, can you anticipate when you sign this agreement that 5 years from now or some point in the future there's going to be a defamation claim, there's going to be an intentional tort? This is why I emphasized earlier, this is a 3211 claim. She'll probably testify, when I signed this, I had no idea that there would be an intentional tort waiting for me. So at some point in the future, you can't waive an intentional tort that hasn't happened yet.
With a guy like this, I mean, based on her allegations that he sexually abused her, raped her, et cetera, she could not foresee that there would be an intentional tort committed by him?
I don't know if I'd agree with
Seriously?
that.
With this guy?
Yeah, do you really think? Can you anticipate that anyone is going to commit?
Yeah, I think that if I had this kind of interaction with this man and he puts an NDA in front of me that says what it says, yeah, I think I would anticipate that in the future I could absolutely anticipate a future tort if I sign this document. Yes.
I think that's for the fact finder. I know of no case that says that you, as a matter of law, can be expected to anticipate a future tort after you sign a waiver like this. And the Clapper case.
If you're getting paid for something in the future, can you agree to waive something that's going to happen in the future? You make an agreement, you get so much and so much money, and you agree to waive.
Only if the parties.
I understand that. I'm not asking that question about criminal conduct, which may involve a public policy consideration, but can't you make an agreement about something in the future if you're getting paid for it?
Only if the parties intended to dispose of such a claim or that issue was in dispute at the time of the release. The cases are clear on this. The New York Court of Appeals and a lot of the appellate division rulings have said this over and over. Uncontemplated transactions. You can't contemplate an intentional tort 5 years from now, can you? And the Clapper case says, maybe it's dicta, but it's in Clapper, that you can't contemplate the waiver of an intentional act down the road. So,
even where someone has perpetrated intentional acts against you already, which are the basis of the NDA in the first place. I mean, let's put this in context, right? The entire purpose of this NDA is that she was alleging he raped her.
So she's
right.
waiving.
So he then, has this NDA drafted according to her allegations, and I have no reason to question them. Forces her to sign this under pressure, right? But it is beyond me how you say in that context that she should be surprised that a future tort by someone who has already engaged in a criminal act, forget it, a criminal act.
Okay, so let me ask this.
No, you don't get to ask the court questions.
She-
That's not how this works.
this
Nice
court-
try, though. And I'm going to give you another 30 seconds because you're way over time.
Okay, if this court holds as such, that would be maybe the first time this court has done such a thing, that you can anticipate an intentional tort, defamation, years down the road because of something he says. I think
I
that's
didn't say all that, but you
but
can
that's-
ask, you can
an
say
issue-
whatever you want to say.
It's an issue for the jury. Did you expect him to do anything to you in the future after you signed this? She'd probably say no, and she certainly didn't think he would defame
That
her.
would be surprising, seeing as she was under such duress and in such fear that he would come after her and her child. That those two things kind of don't go together, but you'll have time.
But I know of no case.
You'll have time on rebuttal, counsel. I've given you more than enough time. You may proceed.
Thank you, Your Honor. May it please the court, my name is Danya Perry, and I represent Leon Black, who is the defendant respondent in this matter. In seeking, Mr. Bergstein just said that it would be new law if this court were to hold that parties can preclude a future act.
Well, counsel, would you agree that there is case law that it is an agreement not to release any claims against a claim that has not yet accrued is unenforceable as a matter of public policy?
No, Your Honor, there is no case that says that.
What about the Baum case, the Southern District?
That is a Southern District case. I thought we were talking about in New York court. The Southern District case, which...
Southern District is a New York court. It's just not a state court.
Correct, Your Honor, and I'm aware of that. That case does not, it does have a statement about public policy, but it relies on, first of all, a 1941 Southern District case involving federal antitrust claims, and New York courts, specifically not federal courts applying New York law, have specifically rejected this precise argument, ruling that New York does not permit a party to exempt themselves from the consequences of their own tortious acts in the future, and that is Clapper, to which Mr. Bergstein just referred.
But isn't that what this release attempts to do, is for Mr. Black to relieve himself from the consequences of any tortious acts in the future? Because he asked her to sign a release that said she would take no action against any actions he took any time in the future.
Your Honor, the defamation claims that we were just talking about arise from, quote, matters. That's a quote from the
yes, but the NDA did not limit itself to defamation claims.
No, it didn't. It was
so you're making the argument just on defamation claims, but
That's the only one
it was a
issue.
broad. I'm still talking.
Apologize, Your Honor.
But the NDA does not specify that it's just for defamation. It said claims. So I think that my colleague's question is well put.
Correct, Your Honor, but those claims, the defamation claims, are the only ones that are at issue. It didn't appeal the intentional infliction of emotional distress or the retaliation. So we're only talking about the only future claims are the two defamation claims. And the parties did contemplate. There is some law.
So you're saying that we should assess this only on the actual claims that resulted, not on the fact that this NDA permitted him to safeguard himself from any acts.
Well, we're not talking
including a repeated rape.
Your Honor, if we were here with a repeated rape that had nothing to do with anything that was contemplated by the parties, I wouldn't be making this argument. What we are talking about...
What you're saying is we take this NDA, we've got a case here about defamation. The defamation falls within the NDA. There may be other cases in which this NDA would run into a problem for public policy reasons. So does the NDA get upheld if you're seeking to enforce it against something which doesn't violate public policy? Or does the fact that it might cover something which does violate public policy means that the NDA is out completely?
Your Honor, it does not violate public policy. The law is very clear in New York that if the parties contemplate this, if it's the intent of the parties to broadly release future claims, that is valid, and we cite a number of cases for that proposition. Here, as Your Honor noted, extortion was contemplated. It was specifically contemplated that there are repeated allegations.
Well, she also claims it was false.
She does claim that, but she knew that Mr. Black was likely or almost certainly going to claim it if she came forward. She says at paragraph 186 of the amended complaint that his quote-unquote plan was to, quote, paint Ms. Geneva as an extortionist if she ever gained the courage to report his vile behavior. And repeatedly, she talks about how she was forced to say that she was blackmailing him. So this specifically was very much contemplated by the parties when they were having these extended discussions over months before she signed this agreement.
So just to pick up a little bit, so she was not really concerned about a future intentional tort here. She was not concerned about a future intentional tort. She was concerned that he would besmirch her reputation going forward as trying to extort him. Let's do this again. She came back from Russia after a year. She made an overture to meet with him and discuss some kind of peace arrangement.
Correct.
Not like he reached out to her, she reached out to him. Am I right, based
That
on
is
this
correct.
record?
She came back to...
So they sat down, and we weren't in the room when she signed it. I know what she said. I get it. But it's signed. Now, 5 years have gone by. No communication between them at all. She sees him say something about being self-righteous that I never, whatever he said. She didn't like it, just like a lot of people who were allegedly victimized in the Me Too situation. So she went on her Twitter and outed him. And that's why we're here now, correct?
That is correct, Your
And that's after benefiting to the tune of $9.5 million.
Over 5.5 years. And just, I do want to clarify one thing. There were not monthly checks, certainly not with memos. There was an account that she set up for the purpose of receiving these funds month in and month out. And so there was not even that kind of contact, which, by the way, there is no case law that says receiving money, millions of dollars, is itself continuing duress. So to go to that point, this was year in, year out. There is no case law. Talk about extending case law. This would bring the law of contract in the state to a screeching halt, or really beyond its breaking point. There's no case law that says you can sit and accept the benefits, the fruits, to the tune of millions of dollars of an agreement that you knowingly entered into, and then not say anything, not repudiate, not protest.
There are cases that say that if you claim that you're under duress, then you can't be held to have to acceded to that,
But
and
the
that can
rest
still
can't
be
be the
raised.
checks, right? Is that not what you're saying?
That I am saying that. That is not payment of money. That was exactly what he had contracted to do. Is not duress. Then there's no such thing as a contract. You pay someone money and you're threatening them.
Where in the release does it say that he'll pay her $100,000 a month? I don't see that.
The release says forgiveness of loans, help with her immigration issues, and such other consideration as to which has been agreed. And she alleged in her complaint that she knew exactly what that was because they discussed it many times.
But if he hadn't
including-
paid her the $100,000, she couldn't have sued him for that, right?
She could have sued him. They had an agreement.
Where is it? How could she sue him when there's nothing in the agreement that says anything about $100,000 a month?
First of all, there is $100,000 that is specified, and he did pay
That's
her
a
that.
one-time payment.
And then it says provide other consideration to which has been agreed, which was.
But if it's not in writing, we all know what our case law says about contracts, right? If it isn't written down and not within the four corners of the agreement, it doesn't exist. So how could she have enforced a $100,000 a month that was not explicitly detailed in the writing?
But there's no merger clause here that it has to be in writing.
It doesn't say that. There is no merger clause that says that. This is a simple one-page agreement that says such other consideration has been agreed. She doesn't deny that it was agreed, and she says in her
She agrees
complaint.
it was not, that she does deny that it was agreed. She doesn't deny that she signed it. She denies that she agreed because she signed it under duress. So by
That's a
saying it was
separate
under
issue.
duress,
Yes.
she's denying that she agreed.
She does not deny. She says in her complaint, I believe it's paragraph 246 of the Second Amendment complaint, that she understood that she would be paying $100,000, as Mr. Bergstein just said, every month for as long as she kept her mouth quiet. As long
the
as
fact is that the money was paid.
it was paid every month.
Then, just to come back, if the NDA covers a situation which it legally shouldn't, does that mean that the NDA is invalid?
No, Your Honor, it doesn't. There is no public policy that says, I mean, we're talking about as applied here. And as applied, there is nothing that violated public policy, and I don't think they even argue that in either below or here.
There's no violation of public policy in saying you can't defame. You can't defame the person.
Right. Particularly when it relates back to the entire purpose for this agreement, which was to cover the entirety of their relationship, past, present, and future.
May I ask another
Yes,
question?
of course.
The very paragraph that's been discussed that addresses past, present, and futures in NDAs, I haven't had the time to really do a global research of that particular issue. Did your research disclose whether that particular provision has been challenged in other litigation? In other words, exactly as worded in this NDA.
Yes, Your Honor, there are cases that cover exactly this type of language. I refer Your Honor to a decision by this court, Scott's Company versus Ace Indemnity Insurance Company, also a decision by the Second Department, Clapper versus Graziano. Both of them have very similar language about claims that the plaintiff has ever had, has now, or in the future. That's from Clapper. So there are cases that have upheld these future-looking claims, for sure.
Thank you.
Thank you, Your Honor.
You have,
To respond to the last point, Clapper has language that, in Clapper, the plaintiff lost because it was a reality TV case, but the court did say the allegations against the corporate defendants are insufficient to demonstrate willful or intentional misconduct, which would invalidate the release. That's what we have here. We have willful, intentional conduct. This is not a Clapper situation. The New York Court of Appeals said in Mangini, the cases are many in which the release has been avoided with respect to uncontemplated transactions, despite the generality of the language in the release form. It's an issue for the jury whether this was contemplated. Did she know that there was going to be a defamation case waiting for her someday or some other intentional tort? We can't answer that under Rule 3211. Thank you.
Did she know that there'd be a defamation case waiting for her if she defamed him, after she signed this NDA and took $9.5 million?
If she defamed him, but she didn't defame him under the complaint. Under the complaint, she told the truth. That's the problem with deciding an issue like this before discovery.
thank you.
You mean
Thank
she
you.
expected that he's going to say what she says is the truth?
Say it again.
She expected that what he's going to say, what she's saying is the truth.
I don't know what she thought he would say, but I don't think she expected him to call her an extortionist. That's the problem.
I mean, what do you suggest she expected he was going to do after having paid all this money over all this time? She went public against him.
That's a good question for deposition. What did you think? What do you think he would say if you said,
Your suggestion, she didn't think that this was going to happen.
Maybe
so
she
what
didn't.
did she think is going to happen?
Maybe she didn't think he'd say anything, or he would
He
say
paid $9.5 million for her to remain silent, and she doesn't remain silent, and she thinks he's not going to do anything about that.
he might not defame her, but he could bring a lawsuit. Maybe
Well, he did. He brought a malicious prosecution lawsuit.
evidently, and if he wants his money
That's
back,
not an intentional tort.
right? But
He claimed that by starting this action, she destroyed his life. And a judge so far found that way. I mean,
well, the same judge who dismissed this case, so of course he's going to say that the case was malicious.
Thank you so
Thank you.
much. Williams versus Mount Sinai Health System.
I'm back. Okay. Stephen Bergstein for the plaintiff. This is an entirely different case. This is a disparate treatment claim brought under the New York City human rights law. The essential...
counsel, where on this record, and we've read it and we've read the briefs, where on this record do you have a basis for racial animus of any kind with respect to the hospital's treatment of Dr. Williams and addressing his competency as a neurosurgeon?
Because Dr. Williams is black and Dr. Comparator is white, and Dr.
That is not enough,
I think-
counsel. You know that is not enough.
I do think it's enough. There are
No,
cases.
it's not enough.
There are cases.
What in the record, where does anyone say anything? Anything.
Or do anything.
Or do anything. Intimate anything that any of the decisions, any of the actions by the hospital were based on the fact that Dr. Williams is an African-American man.
There are cases going back decades that if you can prove intentional discrimination based on disparate treatment involving a comparator.
Where's the Dr. Williams was offered an opportunity to resign and didn't take it. Dr. Comparator was offered an opportunity to resign and took it. Dr. Comparator went on to have a great career afterwards, presumably. Dr. Williams chose not to take the offer, and he's probably had all sorts of difficulties as a result.
It's more complicated than that. Initially, Dr. Betterman tells plaintiff, we want you to resign and we'll give you a couple of months. And that's similar
Same thing with Dr. Comparator, right?
Except what happened the next day, and this is what the lower court overlooked in the opinion. The next day, Betterman comes back to the plaintiff and says, you need to resign now, immediately. And plaintiff says, wait a minute, I thought I had a couple of months. And Betterman says, no, you get out of here now. And so that's very different from how Dr. Comparator...
So is that the disparate treatment that you're referring to?
Dr.
The timing of the decision?
Dr. Comparator was given a soft landing in at least 5 or 6 different ways, by my count, in this record, where they continually went out of their way to help him. If you can't find work, you can stay here. We'll give you a positive review. We know it, Dr.
That was after he had already agreed to resign, right? That they gave him these other options.
But they were so...
Was it after he had already agreed to resign, right? Because we have to line up the treatment to see where is it different.
The difference is what Dr. Comparator did and his mistakes as a neurosurgeon.
No, we're not talking about the mistakes. So you can't say, well, I was a bad doctor, but that doctor was worse than me, and so therefore it's disparate treatment. What you can tell us and argue to us is that the treatment for them doing bad jobs as doctors were different, and that difference was based on race.
Dr. Williams was pushed out at lightning speed once they decided they wanted him out of the hospital, and that is not the way they treated Dr. Comparator, even though we know from the record what he did as a neurosurgeon operating on the wrong side of somebody's brain. Plaintiff did nothing.
Did Dr. Williams' response indicate a resistance to resigning? Doesn't he say he needs time to think about it?
And they didn't give him time to think about it.
Versus Dr. Comparator, who decided to resign when given the opportunity to resign.
And they gave Dr. Comparator like 3 months or longer to find work, and they gave him a positive review. It's almost like they were doing him a favor, either because
he agreed to resign. That's the difference. The difference, what's disparate here, are the reactions of the people, not the treatment. Right? One doctor says, I'll take the opportunity to resign. The other doctor says, let me think about it. That's the difference.
Dr. Williams was not given the grace period that Dr. Comparator...
Had he agreed to resign, he would have gotten a grace period too.
But the record
if he wasn't, he could have argued that that was the disparate treatment, wherein he was asked to resign and he accepted that offer, but wasn't given the grace to find a new position like Dr. Comparator.
But the record's more nuanced than that. Dr. Comparator was given every advantage to find other work. Plaintiff wasn't given that advantage. They told him, you get out of here now.
You keep on ignoring the difference between the position of the two doctors. And you can continue to do that. We are not going to ignore that. That is the essential difference factually here.
When you give a comparator much more favorable terms of their departure than the plaintiff, who belongs to a protected class, that's a disparate treatment.
Dr. Williams would have had it too had he agreed to resign. They weren't telling Dr. Williams, you're off the payroll tomorrow. They wanted his resignation now, and then he would have had time also.
They didn't give him any time to make up his mind on whether he
He
wanted.
never agreed to resign.
They didn't give him any time. They said, you have to resign now.
Okay, you'll have time on rebuttal.
May it please the court, my name is Kevin Fee. I represent Mount Sinai Health System. I want to follow up on two things. The comment counsel made about lightning speed. Before I do that, I just want to say I agree with something he said in his reply brief. In his reply brief, he said at page 3, the hospital took steps to separate Dr. Comparator from the hospital altogether, and they did. Now, on lightning speed, let's talk about lightning speed and compare it to Dr. Comparator. Monday, August 1st, 2016, Dr. Catan, who's the head of neurosurgery at Mount Sinai West, has his weekly meeting of the neurosurgeons, and Dr. Comparator does not report that he had a bad outcome on a surgery over the weekend. Dr. Catan finds out about the bad outcome because Dr. Catan swims at Columbia University, and the patient who had the bad outcome was another swimmer. So he finds out that his employee, Dr. Comparator, has not reported this to him, which he is supposed to do. The next day, Dr. Tracy Breen, who's the chief medical officer, asks to have an investigation of the quality assurance issues on that surgery that happened over the weekend. Thursday, August 4th, the hospital issues a suspension letter of Dr. Comparator. He's suspended with pay for 14 days. He cannot do anything at the hospital while pending an investigation. There is an investigation which concludes on August 18th.
By August 19th, he's agreed to resign.
Yes. What happens, even before you, let me be clear about that. The two issues that were being investigated in the suspension letter was his treatment and his failure to report it, a professionalism issue.
That wasn't the first time he operated on the wrong side of something.
This is not a wrong side question. This was
Okay.
someone who suffered a stroke, and there was a craniotomy, and the question was, there was questions about whether his surgery was appropriate. So they were looking at two things. One, the appropriateness of his surgery, and his professionalism issue of him not reporting it to Dr. Catan as he was supposed to. On the 18th, what comes
This is all happening in August.
all happening within 18 days,
In
yes.
August, and by August 19th, he's out, although they let him stay on.
What they do is they say to him, the result of the investigation is you met the standard of care. There isn't an issue about your care of the patient, but there is this professionalism issue. And they tell him, you're not getting a renewed, we'll give you some time to find a new job. It's not that he offered to them, they told him, you're not keeping your job. And what the hospital does, though, is the hospital also comes back and says, Dr. Comparator raised all these issues about I had assurances that I was going to get a contract before, and I turned down another job, I have a claim against you. And the hospital's legal counsel said to Dr. Comparator's counsel, I want a release. They negotiate a release that has in it a resignation start date of December 31st.
They actually gave him a favorable review based on the testimony that I understand in the record to get him out of here, to convince him to go.
I don't know that was the part of it to get him out of here, but he was given, the review that was given allowed him to keep his privileges. He'd never used the privileges. They went their separate ways. Dr. Comparator, testified that I wanted out, I had nothing to do with it, I left.
But in any event, with respect to this case, the speed in which they did this, they didn't set up a special QA committee for Dr. Comparator, did they?
They had
quality assurance review.
They did have another,
But a special committee, they didn't do that for Dr. Comparator, correct?
No, what they did do was what they've done in all the cases, including what Dr. Breen did with Dr. Williams back in April 2016 on the first issue. They brought in another neurosurgeon to opine about it, and that was Dr. Kalman Post. In Dr. Comparator's August investigation, they did bring in another.
I just want to make sure I'm following you when you get into this
And I want to
lightning
refocus
speed.
you on this
Right.
plaintiff.
Go ahead, focus.
Go ahead.
When you're saying lightning speed, that's just this one incident, right? We're not talking about the other incidents involving Dr. Comparator, right?
I'm talking about when he's using the term lightning speed, that Dr. Comparator was not dealt with at lightning speed. Compare that to the speed with Dr. Williams. Dr. Williams, what happened was on September 19th, 2017, more than a year later, Dr. Breen writes an email to legal counsel and others in the hospital saying, there's an issue that's come up with Dr. Williams. It's going to be reviewed in the monthly neurosurgery quality assurance meeting at the beginning of October. After that's done, I'd like to review this. After that meeting, which happens on the 4th, Dr. Catan writes a written report to legal counsel and those others involved and details the 3 cases, patients B, C, and D. Then Dr. Betterson calls up Dr. Williams and says, I think we'd like you to resign. And he tells him the issue is these 3 cases. And he says, we'd like you to submit your resignation now and we'll give you several months to stay on. He's told the same thing the next day. And we were questioning the record about, I was looking at the record while I was listening to counsel. The next day, Dr. Betterson called him again and said, I needed you to resign immediately. And he said, and then Williams said, I thought there was some discussion that I had 2 months to make up my mind. And there was never that discussion that he had 2 months to make up his mind. It was whether they would give him several months to stay along. So anyway, he doesn't react. He does not accept Dr. Betterson's suggestion. On August 18th, he is suspended with pay for 14 days, as was Dr. Comparator. There's an investigation. Dr. Breen interviews all the witnesses. There are opinions from other neurosurgeons. In this instance, they get 3, not just 1. Then, first of all, they're not relying on Dr. Catan, and they're relying on 3 surgeons. He's actually given more protection than Comparator got. And then at the end of the investigation, they determined that not only does his standard of care for those 3 patients, at least 2 of them, not meet the standard of care, but also his conduct with cutting and pasting a neurologist examination note and passing it off as his own was a professionalism issue that called question about his candor with the hospital and his judgment, and that was an additional separate reason for his termination, and then he is terminated.
Thank you.
So, thank you.
Just a quick point why I think this is an issue for the jury. On this October 12th, Dr. Williams was told, you need to resign immediately. Nothing about a grace period. Nothing about a period of time like we did with Comparator, Dr. Comparator, to find other work, will give you a positive review. That was not offered to the plaintiff. That will give you every advantage you need, including a positive review, if you resign now. That is not the way they treated Dr.
That was negotiated. There was a negotiation between counsel in that case because he had agreed to resign so that they could talk. But here he is it on a Thursday or a Friday they tell him to resign? He waits until Monday and he doesn't agree to resign. So they end up terminating him. Had he agreed to resign, they would have had a negotiation in which he probably would have ended up with the same package that Dr. Comparator ended up with.
We're making that assumption. They would have given
But you're skipping the fact that he never agreed to resign, and Dr. Comparator did agree to resign. So of course there are going to be different consequences following from what each one did.
But when they told him you need to resign immediately, there was nothing in that discussion, well, if you resign immediately, this is what we'll do for you. If they negotiate something with Dr. Comparator that never comes up with Dr. Williams, that's disparate treatment.
Okay,
Thank you.
OH 126th Street Housing versus Berkeley Insurance. You may proceed.
Good afternoon, Your Honors. Andrew Akron on behalf of plaintiffs' appellants. In this case, the lower court denied plaintiff's summary judgment motion, but then took it a step further to conclude that the damages plaintiffs assert in this case are consequential damages and waived by the construction contract. That determination and the determination to deny the summary judgment motion is based upon an incorrect interpretation of the underlying construction contract, as well as the lower court ignoring that plaintiffs assert that the surety in this case breached the surety bond or the performance bond, and that they have separate obligations beyond just the construction contract, and therefore plaintiffs are entitled to damages for the surety's breach of the bond. And in this case, the surety, which acknowledges and doesn't contest in this motion that the plaintiffs provided proper notice under the bond and proceeded as they were required to under the bond, the surety denied coverage, denied liability under Section 5.4 of the bond. Because the surety did that, the remedies afforded to the plaintiffs under the bond are governed by Section 6, which allows and permits the plaintiffs to pursue any and all remedies as against the surety.
Counsel, my understanding of the record, and correct me if I'm wrong, you were moving for summary judgment on liability under the bond, under the agreement with the surety. Liability, not damages. And it is my understanding that it was during oral argument that this notion that the plaintiff was made whole by getting all the money through the bond sales and from the government, et cetera, that they have no damages. And of course, they raised the issue that all the damages here allegedly were consequential in violation of the waiver provision of a contract which the surety was not party to. So you're here because the court went beyond what was asked of the court, correct?
Absolutely, Your Honor. That is absolutely correct. In fact, the waiver of consequential damages was never raised at any point during this litigation, not in opposition to this motion. The court seized upon this.
But anyhow, it's your position that if the violation of the bond, the surety doesn't operate according to, they don't step in to take care of completing the contract. To put it simply, they walk away from the situation, and then it turns out that the owner was entitled to have had the surety step up and complete the job, and the surety didn't do that, you're able to go after them. You would be able to go after them for consequential damages.
Yes, Your Honor.
They just breached their whole obligation under the suretyship.
Yes, Your Honor. Pursuant to Section 6 of the bond.
That's your position, right?
Yes, Your Honor, that
and
is.
Section 6 provides for that.
Yes, Your Honor. Also, I want to note that the waiver of consequential damages in the underlying construction contract, which was relied upon by the lower court in determining that there were no damages, is also incorrect. That position is incorrect. Section 14.2.4 of the rider provides for that the additional architectural costs, development costs, interest for loans, seeking additional financing are all to be direct damages as the result of the contractor's breach of the underlying construction contract. Those are the exact damages that plaintiff is asserting and asserted during oral argument when this issue was raised for the first time. And as Your Honor correctly pointed out, this was a motion for...
Section 6, when it says, "And the owner shall be entitled to enforce any remedy available to the owner." What does that mean to you?
Well, that means, and other courts in other jurisdictions have found, they're entitled to seek anything, meaning cost of completion, as well as damages stemming from, including consequential damages, or what would normally be considered consequential damages, stemming from the surety's failure to act under the bond. So in this case, under section, surety denied liability under Section 5.4. Section 6 provides that the owners, the obligees under the bond, can pursue all damages, including the cost of obtaining additional financing, delay damages, overhead, architectural increases, contract overages, anything that would be available to the owners, either in direct damages or as consequential damages, are available as damages under Section 6 of the bond.
Thank you. You have 5 minutes.
May it please the court, my name is Charles E. Williams III. I'm a partner and shareholder in the law firm of Bakar, P-E-C-K-A-R, in Abramson, and we represent Berkeley Insurance. I respectfully direct the attention of the court to page 230 of the record, which is the bond. And what there are three sections, two sections of the bond that opposing counsel leaves out, which changes it. And then the section that he talks about has a provision when you realize the funding of this project came from tax-exempt credits.
So what happens if the surety company just walks away from the bond?
Well, could I start with the first point? That it is not a separate contract. Read section 1. Section 1 of the bond is that the principal and the surety are jointly and severally liable to the owner pursuant to the terms and conditions of the contract. That's a basic requirement. And then also look at after section 3 comes section 4. And section 4 says there are no conditions preceding unless it can be shown by the surety that the timing of the notice could be prejudicial. All right? That's left out. The point that the surety made was, and it's clear, and I would respectfully direct the attention of the court to the deposition of the owner. It starts at 438 and runs, the part that I'm looking at, runs through 474. And one of the reasons, and if you start at 478 and you look at the section 3.1, which is the section that the plaintiff appellant notes, it says that one of the requirements is that the owner, in this case the plaintiff, will agree to pay the remaining contract balance pursuant to the construction contract. Without getting into what was spoken here, I want to point this out because, as you will see in the sections I had said, that the breach of contract and the claim against the bond came in July of 2022. The substantial completion date of the contract was May of 2022. Now, the way the contract is being financed is the plaintiff had to sell low-income tax credits they go to banks and insurance companies. And that was somewhere, and it comes in here, to the tune of $3 million. That was the equity contribution of the plaintiff. At the time of the termination, which was after the substantial completion date, which also comes in the pages I've told you, the job was 15% complete. 15% complete. It was supposed to be a 5-story building, that Odyssey House, which is the entity that was going to run a homeless shelter and a mental health shelter, for a contract with the state agencies.
So is your point that the owner let this slide for too long?
No, well, could I go a little further? In this, what is, and the reason I cited only one case, is that for there to be a proof of a breach of contract, there has to be economic loss. If you look at, I believe it's 473 or 474, there is a discussion going on, and here was the concern, that as you read this, pursuant to low-income tax credits, if the tax credit date, which was May of 2022, is not met, there is the, let me see, what's the magic word?
Counsel, are you claiming that if a party seeks summary judgment just on liability, That
This is really a bifurcation motion. They're only talking about liability.
Yes.
But
Are
if
you
you
claiming that a defense to a motion for summary judgment based on liability is that they didn't suffer any damages?
At all. At all.
Is
And
that what
if
you're
you look
claiming?
at 473, what is admitted by the plaintiff is what is called a loan is not a loan, it is a grant. That what this grant is that the
Your red
state,
light is on, and what I wanted to ask you is, what does paragraph 6 mean to you? What does it mean when it says, and the owner shall be entitled to enforce any remedy available to the owner? What, in your view, what does paragraph 6 mean?
this is where the mitigation came.
Answer his question. What does paragraph 6 mean
That if they had
to
a
you?
remedy, they could enforce it. But they didn't have a remedy because they mitigated the damages in total. And what they are.
All right, thank you. We're going in circles now and your time is up. Thank you. You have 2 minutes.
Thank you, Your Honors. Without going too far astray, yes, this was a motion for summary judgment on liability. The damages aspect of it, which my learned colleague and the court focused on, was not relevant to the motion for liability. And that's why it wasn't briefed. The damages issue was not briefed and was raised for the first time at oral argument. The consequential damages issue and the waiver was raised for the first time in this case at oral argument. What essentially
I'm going to be sure I'm understanding this correctly, but it is your position that you're entitled to the posture that the case is in now, you're entitled to consequential damages.
Yes, we're entitled to consequential damages and we're entitled to summary judgment. And we're entitled to cost of completion damages as provided under section 14.2.4 of the rider to this contract.
Which would be in excess of whatever they got through the sale of those credits or bonds, correct?
Yes, Your Honor. And
So
also,
they weren't made whole.
They were not made whole. And as is evident in the affidavit that was submitted in support of the motion for summary judgment, further funding was obtained from the state by the sale of additional tax credit bonds. That's not free money. That's money that it has to be paid back. That counsel has made a point of saying that the state is just eating the money and they're not going to seek to recover the money, and that's just not the case here. So
bondholders want to be paid.
Yes, Your Honor. And so in summary, the lower court erred in finding that there was no summary judgment on the issue of liability because she reached to damages. The lower court also erred in determining that the damages expressed by plaintiffs during oral argument, which were these architectural fees, the additional financing fees, and interest, were consequential damages when they're not. They're actual costs of completion under the construction contract.
Thank you.
Thank you, Your Honors.
Melikov versus 66 Overlook Terrace. You may proceed.
May it please the court, Christy Kenzig on behalf of defendant appellant Omar Fakouri. The instant appeal should be heard on its merits, and upon review, the contractual indemnification cross-claim should be dismissed against Mr. Fakouri. First, the appeal should be reviewed on its merits pursuant to CPLR 5520. The legal issues and the evidence put forth between the July order and the September order are the same. Public policy favors hearing appeals on their merits. There would be no prejudice to the co-defendants. The rights of the parties are going to be directly impacted by an order on this issue, and therefore it's not moot. The interests of justice would be served, and at a minimum, the notice of appeal should be treated as a premature notice of appeal. Turning now to the merits, the indemnification provision contained in the proprietary lease is violative of General Obligations Law 5-321. This court...
But there's no evidence in the record, as I understand it, where the respondents had any control over the means and methods of the work within this apartment. In other words, they're the owner, the lessee, I mean, you represent the lessee, but there's nothing on this record that suggests that they had any role to play. In my understanding, in the absence of any evidence of record that would suggest that they played any role, they would not be violative of the GOL.
So earlier this year, this court decided ESV Windsor Owners Corp., where Tudor, who is one of the defendants here, was a defendant there. This exact same paragraph, Tudor was not found to be negligent in that case, and the contractual indemnification claim was dismissed as against the tenant, owner, or shareholder without any finding of negligence, and it's the identical, exact same language that is used here.
Your appeal is from a July 7th order.
Yes.
2023, right?
Correct.
But on September 7th, 2023, Supreme Court granted a defendant's motion for summary judgment, and you didn't appeal from that order, right?
Correct. That's why we're...
So why isn't that order, which was not appealed, now we're not bound, the appellate division is not bound by law of the case of what the Supreme Court does, but you've got an order below which finally determines that issue from which you didn't appeal. So why doesn't that moot your appeal?
That's why I'm asking the court to use its power under CPLR 5520, which in the interest of justice...
Why should we do that?
Because the legal issues are the same. So the timely filed notice of appeal is about contractual indemnification, which is the same issue addressed in the September order. The not filing of the notice of appeal was inadvertent. It was not intentional. And again, public policy does favor resolving issues on the merits. There is no prejudice.
On the merits, I mean, you were supposed to get written consent and you never actually got written consent. Isn't that so?
That's not so. We did get written consent. The
In
issue...
an email, right?
In the email, yes.
That's not, it doesn't seem like that's what the lease was talking about.
Well, so it is. The lease says written consent. Nowhere in the lease does it mention an alteration agreement. So if we're looking at the four corners of the lease, it says written consent. That is a plain, unambiguous...
What specifically does the email say, which you say means that they were granting written consent?
Sure. Mr. Fakori sent an email to the board saying, here's everything, let me know if you need anything else. And they responded in an email saying, that's it, it's correct. So that is the written consent.
If someone is supposed to submit a board package, which he was required to do before doing the alteration, and they acknowledge we have all the papers that we need to evaluate this, you're saying that's consent?
Yes, and there's not a dispute.
No, yes, okay, we agree. I got it. I got all your submissions. I got all your submissions equal a yes.
Because it was also, let me know if you need anything else. Yes, that's it. It's correct.
That's it.
That is
We've got the
definitive.
papers
We've got the papers
we need.
But also that it's correct. There's not, it's correct as to this one document you sent us, but we still need something else. I think it is very typical that if you get that email, you don't think, okay, there's something else I have to do. They'd already discussed start dates. They didn't ask for anything else. There was no follow-up after that. I think that is reasonable to say, okay, they've given me the consent, and there is no dispute that he...
All right, you'll have time on rebuttal.
Thank you.
Good afternoon, Your Honors. Elisa Zeltz, we represent defendants, respondents, Overlook, and Tudor, who I'm going to refer to collectively defendants, respondents. First of all, respect to the appeal. Fakuri doesn't dispute that they did not appeal from the second superseding order. That's the September 7th order, which goes to the point, Your Honor, I think asked, isn't it true that the owner defendants were not actively negligent? And in fact, that's what the court held in that September 7th order. They said that the only possible liability of the owner defendants is under 241 because they didn't control. Okay, so should we apply 5.5?
Why doesn't that order render this appeal moot?
It does render this appeal moot, and that's our position, that this appeal should be dismissed because it is moot. But Fakuri is asking this court to hear the appeal from the September 7th order, even though they didn't appeal from it, because they're saying that the court has the power to do so under CPLR 5520C. Now, that rule is generally applied when you have an order and the party appeals from the order, but then you have a judgment, and the party does not appeal from the judgment. The order is subsumed in the judgment. In those cases, the First Department has said, okay, we're going to treat your notice of appeal from the order as a notice of appeal from the judgment. That's not the case here. We have two totally, entirely separate orders. We have the July 5th order, which was dealing with motion sequence number 8, which was for Curie's motion to dismiss our claim for contractual indemnification against him. And then we have an entirely different order, which just is the September 7th order, which decided a motion made by the plaintiff for summary judgment, and it also decided motion sequence number 8, which was the owner defendant's motion for summary judgment. So Curie has not pointed to any case law where, in this type of case where you're dealing with two entirely separate orders, where the court has said, okay, we're essentially going to forgive the fact that you didn't appeal from the September 7th order, and we'll just say that your notice of appeal is sufficient and it will treat as a premature notice of appeal. Just very briefly with respect to the interests of justice, Curie has to know, they knew there was a September 7th order was out there, but they filed their brief and they don't even mention that order. They don't even bring that order to the court's attention when it's out there and it's clearly relevant, because the court decided that our clients are entitled to contractual indemnification as a matter of law. I don't think the interests of justice really weigh in Curie's favor. Okay, two other points with respect to, is the indemnification provision enforceable? Yes, it absolutely is. And was Curie's indemnity obligation triggered? Yes, it was. One of your honors pointed out, yes, under General Obligations Law 5-321, where the indemnitor is found not negligent as a matter of law, which is the case here, that the indemnity provision, which provides for indemnity in favor of the indemnitor, even if it's negligent, it does not run afoul of that provision. And so the indemnity provision is absolutely enforceable. Was Curie's indemnity obligation triggered? Yes, it was. Even aside from the written consent argument, which I'll get to, there's just a less convoluted way of finding that that the indemnity obligation was triggered. It's triggered by a breach of the lease. One of the provisions in the lease state that you have to comply with the house rules. One of the house rules states you have to sign an alteration agreement before you do a renovation. Curie admits this in their brief. They admit this in their brief. So they admit that they didn't sign the alteration agreement. They admit that it was a breach of the lease. But what does Curie argue? Oh, well, you didn't stop us. We went in and we did it anyway. So you must have waived it. That's not a waiver of a contractual provision. You have to show a manifestation of intent to waive that provision. The owner defendants did not waive a provision just because they didn't even know when Curie's, they don't know what's going on in the apartment. They haven't, yes, there's emails, yes, there's contracts, and there's licenses, and there's documents being sent to them, but without this signed alteration agreement in place, which there's no evidence that they intended to waive that requirement by not following up. And that's actually something that the lower court said in the September 7th order, which was correct. They said it's Curie's burden to go ahead and get it. Thank you.
Thank you so much.
I apologize.
You have 1 minute, and I'm holding you to that 1 minute.
Thank you. I will be brief. First, it's not moot. As I said before, the rights of the parties will be affected by a determination on this appeal. Turning to E.S. Windsor, again, any liability that would have been found there would be comparable to what would be found here, as it was a statutory obligation to do something, which for that, Windsor was obligated by statute to remove the lead, and that was the basis for finding them liable there. I think that would be comparable here to any obligation under labor law. Then turning again to the written consent, if you're looking at the House rules, that just supports my argument that written consent and the alteration agreement are separate things because it does not use them interchangeably. It discusses written consent and it discusses the alteration agreement. Same thing in the alteration agreement. They are never used interchangeably. Additionally, the proprietary lease states that the House rules can be amended by the board basically at will. So if they want to excuse the obligation to have the alteration agreement, they are able to do that. Thank you.
Thank you. Ingram, Uzek versus McCuller. You may proceed.
Good afternoon. May it please the court, Alexander Truitt for appellant. The trial court denied appellant's motion to dismiss the cross-claim for legal malpractice in the decision in order. The trial court found that respondent had alleged 3 separate theories of legal malpractice. The first one was appellant's alleged failure to respond to a demand letter commanding respondent to cease.
It was the failure to write a demand.
Excuse me?
Oh, it was the failure
Cease and
to
desist
respond,
letter.
failure to write a cease and desist letter.
It was the failure to respond to a cease and desist letter, correct, yes. And the cease and desist letter was demanding that he refrain from trying to marry an alleged incapacitated person. The second alleged theory of legal malpractice was once a guardianship proceeding began, the appellants filed a cross petition rather than a motion to dismiss.
Nothing else, why doesn't your failure to respond to the cease and desist order provide a basis on a pleading motion for denying your motion?
Well, Your Honor, in New York, attorneys have wide latitude to exercise discretion in strategic decisions. It's called
So
the...
what was the strategic decision in ignoring the cease and desist letter when Mr. McCuller wanted it responded to? At least those are the allegations.
A cease and desist letter is, they're sent every day, and some are responded to and some are not. It doesn't make it a...
What was the strategic reason?
Counsel, you're...
Oh, sorry, the strategic decision is that Mr. McCuller did not want to give them what they asked for. Now, Mr. McCuller's affirmation in opposition to the motion said he wanted the appellant to go to them and suggest an early settlement where he could marry an incapacitated person in exchange for allegedly agreeing to not...
But it seems to me like you were accepting the fact that she was an incapacitated person when your client is telling you that not necessarily, right? I mean, who are you working for?
At the time, sorry, I just want to understand the question. You're saying that at the time of the response that we're accepting that this person was an incapacitated person.
You get approached to represent a client who you've had in the past. He comes to you because he trusts the firm. And he asks for you to address a cease and desist letter, and your firm decides, we're just going to ignore it.
Yeah. No,
we're not going to respond.
Yeah. I understand now what your Honor's question is. And the reason why that's not legal malpractice is it's speculating. It's speculating after the fact.
Speculating.
Yes, it's speculating
And he speculated correctly that by not responding, a proceeding was in fact instituted. And then instead of moving to dismiss, because of course this area of law was completely outside of the wheelhouse of this law firm, you look at me like I'm saying something that's not true.
No, I want to get a chance to answer your questions because Your Honor is...
do.
Okay. So a legal malpractice claim cannot exist when it's dependent on speculative relief. And this is speculative relief because it's speculating that the petitioners who said, do not marry this woman, she is incapacitated and cannot legally consent to marriage, would suddenly say, oh, okay, you can marry her, thank you, or we really
Is there a view of this, and again, we're dealing with a pleading motion, that what the petition is in that proceeding were into, they didn't care whether or not he married the woman. What they were concerned about is that he not get an elective share of her estate. And basically, isn't there a view of this that Mr. McCuller was quite ready to say, I won't take any part of her estate, so you don't have to bother. I'm willing to bind myself that I won't take a part of the estate. So had the cease and desist letter had been responded to and the petitioners had been given what they wanted, nothing would have happened.
So that's not supported by the record. What's supported by the record is what's in the demand letter, that they want him to stop marrying or trying to marry an incapacitated person, and they want to be involved in her care going forward.
And the people who filed this, they weren't relatives of this alleged incapacitated person, correct?
Yeah, absolutely.
They were friends.
They were friends, yep. They were
Right.
best friends.
And it didn't dawn on anybody that perhaps they really had no standing here?
Well, they do have standing.
Okay.
All right. So again,
You'll have time on rebuttal.
I'll have. Thank you. Okay.
You may proceed.
Good afternoon, Your Honors, and may it please the Court. My name is Annie Mahili, and I'm counsel for Mr. McCuller, respondent in this action. This court should affirm the motion court's decision because the motion court correctly held that at the motion to dismiss phase, Mr. McCuller had pleaded facts sufficient to support 3 independently viable causes of action for malpractice.
What did Mr. McCuller want the defendants to do about the cease and desist letter? What was his position as to that?
When he received the cease and desist letter, he wanted the issue dealt with. He reached out to his long-term attorney and said, look, I want to be able to marry Ginny. We've been together since 2008. I've been taking care of her for 5 years. No one's had any issue with it until now marriage comes up. So please figure out a way, respond so that we could get married. At the very least, if they can't get married, they should be able to continue living on the way that they were.
Didn't Mr. McCuller provide them notes to sort of walk through the letter and in a meaningful way to respond to that cease and desist letter?
Yes, he gave them guidance. He was seeking guidance from them. He wanted this handled. He did not want the letter that he hired the firm to specifically respond to go unaddressed because it threatened legal action, and he was very concerned.
He never received any response from the firm saying, we've decided not to do that, and this is the reason for our strategy not to respond?
No, he never received a response from the firm. They just said ignore it. It's not a big deal.
Counsel, it sounds like your adversary is arguing that what your client wanted them to do was to respond in a way that wasn't true, which was to say that he wouldn't marry the alleged incapacitated person. Was that his request at all?
No, that's not accurate. Mr. McCuller, if he had had a guardianship attorney who understood what legal incapacity means as to guardianships and marriage and who understood the implications of this letter, they would have responded and said, look, your concerns are meritless. She's being taken care of. Here's her doctor. You can talk to them. Here's all the ways that Mr. McCuller has taken superb care of her. They've been together since 2008. No one's raised any issues about him taking good care of her or her being at any risk of harm.
Was he willing to not take an elective share in her estate at the initial time when that cease and desist letter was written?
Yes, absolutely. He had complete control over finances for 5 years and had done nothing wrong. He'd improved her finances.
And he
not
clearly
interested
is a
in the
man
money.
of independent means, seeing as he paid over $327,000 in legal fees for this case. Correct?
He paid $172,000 to Ingram, and then they sued for $100,000 more. He's also paid his other attorneys that he's had to hire to try to fix some of Ingram's mistakes and to comply with the onerous restrictions of the guardianship.
So my point being that, yes, he's a man of his own means.
Yes. He had his own architectural practice.
One of the points they raised to defeat the complaint is essentially he agreed to the settlement. In other words, there was a settlement where he said, oh, I'm okay with being a guardian, which they claim a happy day, correct? But if there's a settlement based on information or misinformation that you didn't know about, and had you known about it, you never would have agreed to instruct them to go forward, that kind of vitiates the whole thing, correct?
That's exactly right, Your Honor.
And that was pleaded in the complaint, right?
That's exactly right. Yes, there were favorable mentions of Mr. McCuller's care of Ms. Dawes, for example, in the court evaluator's report, and he was not advised as to the strength of his argument to not settle. He was not advised that he could win if they moved to dismiss the petition, and that there's a ton of cases that I've cited in the briefing that show that a guardianship's not necessary when there is sufficient alternative resources, etc. So that's exactly right. We allege that the settlement was due to malpractice because Ingram did not understand the law and they could not have advised him as to what his rights were. Unless you all have any more questions, I rest on the briefings.
Thank you.
Thank you.
Counsel, you have 2 minutes.
I'll try to be as briefly as possible, Your Honor. So regardless of, well, let's just start. There's no dispute that Mr. McCuller wanted to marry Ms. Dawson. There's no dispute that she's incapacitated. You cannot legally marry.
There is a dispute that she's incapacitated.
No, there's not. She was adjudged incapacitated.
But at the time that the proceeding, that the cease and desist letter, that he received the letter, he disputed whether or not she was incapacitated.
May I correct my statement, actually? So Mr. McCuller certainly in his pleading disputes that she was incapacitated. However, he filed a sworn and verified petition in the underlying guardianship proceeding swearing that, okay, I know she's incapacitated now, I don't want to marry her anymore, and I will wait till she regains capacity.
That was done at the advice of your client.
Whether it's at the advice of my client or not, it's still a sworn statement. This is why you have judicial estoppel, because you can't go back and then say, now that there's a dispute, oh, all my sworn statements that I succeeded on didn't mean anything because I don't want to pay my bill. And now it's also confirmed by the court evaluator's report where she said something to the effect of, okay, it was reasonable for the petitioners to have this feeling about Mr. McCuller at the time, but now that he no longer wants to marry her, I realized that this marriage plan was just a bad idea. So the claim in the beginning had merit. The decision to not respond is simply one of attorney judgment, and the alternative path that a respondent is claiming entitlement to, that's simply hindsight and saying one of potential other reasonable paths. It doesn't mean that the reasonable path Ingram chose was deficient. In fact, the relief that they're claiming that they should have gotten is speculative because it depends on determining that the people who said don't marry her would then suddenly turn around and say, okay, we'll marry her. I understand my time is coming up, but I just want to...
Your time is up. The red light means your time is up.
Okay, thank you,
Thank
Your
you
Honor.
so much. Michael Davis versus YMCA of the USA.
May it please the court, my name is Jay Breakstone. I represent the plaintiff appellant. I think I have something very easy for you after listening to all the cases this morning. So I think
That would be welcome.
I think this is very easy. This is a case, a 3211A7 case based on pleadings. And of course, we know with pleadings,
Counsel, as I understand it, your claim is that there's a separate and distinct claim for negligence against the YMCA, and that negligence claim is based on your theory that they have an in loco parentis obligation to the child, to the plaintiff. Are there cases which hold that an institution like the YMCA and not a school has been held to be in loco parentis for the purpose of a negligence claim?
well, I think anybody can be. I think there are cases that talk about anybody can be in loco parentis.
But that's not what I asked. Are there cases that so hold?
Excuse me, I didn't hear the
Are
last
there
word.
cases that hold that an institution like the Y is in loco parentis?
I've only found cases dealing with schools where this doctrine is utilized, and so hence the question.
There is no such limitation to in loco parentis.
Okay, but is there any case that has utilized, you're answering the question in the opposite direction. The question is, has there been any case, other than school cases, that has utilized the doctrine and upheld the doctrine of in loco parenti in this kind of factual situation?
Yes, and I'm just looking for the particular case, but it's been done in any number of situations. I will grant you that of late, the situations here have been religious institutions, And it doesn't necessarily have to, excuse me, be a religious institution acting as a school. It can be individuals. There is no limitation to that effect. And I think, if I'm not mistaken, and just give me a moment. I think it's in a case called, I think Pitkowitz, which is a decision of this case, of this court. I'm not sure if that was a school or not. And I think your honors have to take a look at some of the Court of Appeals cases like
But a case
Zalak.
like Malik versus Dorchester County Family YMCA out of Maryland held that YMCA, I'm not going to tell you it's identical to the situation we have here, but some similarities that the YMCA is not in loco parentis, right?
Well, it may have not been in that case.
Okay.
But
Well,
under the
in
facts
this
of
case,
this case,
in this case, right, what we have to look at is whether, in fact, there was more than a mere temporary care and custody, and whether there was an intent to support the child on a permanent basis. How does going to a judo class fall within that ambit?
anytime you take responsibility for a child, you are acting in loco parentis. It could be a day, it could be a minute, it could be a year. So when they have that judo class set up, and that child is going to that judo class for an hour every week, during that hour, if that child does not have somebody responsible for him or her, that child would be in a situation you would find, I imagine, I'm not speaking for you, you would find just intolerable. How
So,
can you
and
take
this and this applies. Your theory of it being at any time applies regardless of the age of the child, right?
a minor child? I think a minor
child.
Yeah, unless there's something
Minor
special.
meaning under the age of what? Because minor could
6.
be 17.
It used to be 21, and so now it's 18.
So
Yeah.
that's even more. So when you
can't-
say minor, what are you talking about?
I would say any child under the age of 18 in this state. And I think that's the way the court has to look at it. I don't think there's...
Pretty broad rule you want us to implement. That would mean that every single aftercare program, daycare program, every music teacher, piano teacher, art teacher, every single one, both individually or as an institution, would have to now employ additional staffing just to be the eyes, to make sure that nothing happens to every single child who steps into their building for, as you say, a minute.
That's right, Your Honor. And the fact of the matter is, there is no separate cause of action for loco parentis. And loco parentis is part of a negligence action. In other words, that's why it does not matter what the age of the child is, as long as the child is a child under the law. That's not an issue in this case either, as to the age of the child. Nor should it be an issue as to why they have the child in a situation where they're responsible. They take that upon themselves to take that child in without a parent. What difference of it, what possible difference of it is it a school? What if it's a school that teaches language? What if it's a school that teaches music, as I think Your Honor mentioned? What if it's a school that teaches judo? There is no difference. In loco parentis means you are there in place of the parent. You are responsible the same way a parent would be. And that's what the law provides, because to have something else, to have anything different, is to put children at risk. And the law will not do that. And in negligence actions, in loco parentis is merely a type of negligence.
Thank you. You'll have time on rebuttal.
Thank you.
May it please the court, William Cusack, Ogletree Deacons for Respondent YMCA of the USA. Just for brevity, I'll say YUSA. I take your court's direction. What if a 14-year-old went to a movie theater? Are they in loco parentis? It doesn't expand. And as counsel said, loco parentis is part of a negligence claim, which is duplicative of negligent supervision claim. That's why it was dismissed in the first place. Duty, breach of duty, damages, it's the same exact case, negligence. And your honors are correct, there's no case law outside of the school situation where I've seen in loco parentis. If you want to bring a claim against somebody who mistreats a child, there's negligence claims. The Pickowitz case that my adversary cited, it was an overnight ski trip. Guy was in charge of another person's child. They injured themselves on a ski mountain. It was a negligence claim. Wasn't in loco parentis. The case is cited by.
What about our decision in Diamond Fisher versus Greto from 2000?
I'm sorry, which?
Diamond Fisher versus Greto, our decision from 2000 involving a babysitting context.
Well, I'm sorry, I don't have that case. If there is a case to bring, it would be under a negligence claim. All the cases cited by appellant they were brought as negligence claims. Even if they were brought as, if you could turn them as in loco parentis, there was no case that decided that in loco parentis, outside of a school situation, would be duplicative of a negligent supervision case. So not only does appellant not cite to in loco parentis, he doesn't cite to a case where in loco parentis was not duplicative of the negligent supervision case. And that was outside of the school system. If your honors have no more questions, I'll rest on my briefs.
Thank you.
Your Honors, I use that period of time just to take a look at some cases, and there are cases. There are cases in the Fourth Department that involve individuals who are taking care of children. Not even a school and not a church, individuals. And your honors know that there are cases like that.
Well, I mean, it seems to me that if I leave my child with you, Tom, to take care of my child, yes, I would expect you to act in my stead. But if I, as a parent, drop off my 6-year-old to a judo class and leave without any kind of understanding of how many kids are in the class, how many people are sticking around the, you understand? So I don't see a babysitting situation, a one-on-one, where you turn over your child to one individual as the same as dropping your kid off at a judo class or an art class or a music lesson.
I know I can't ask questions of the bench, but view this rhetorically. If you did that, when you drop your child off at a judo class.
I wouldn't drop off my child, period.
That's exactly right.
So
the person who does drop off that child has every right under the law to view the people who are there, the adults who are there, as being in loco parentis. And that's exactly what happened here. And also the fact that—
You think a parent should make that assumption wherever they drop off their kid? That whatever adult is in the room is going to step in my shoe?
I mean, I hear it when you drop off a kid with an individual babysitter for the day or day after day, but that's not this situation.
The babysitter is just as responsible as the judo people are. It is the essence, with the essence of in loco parentis, and the reason it's negligent, right? It's an item of negligence if the custodian doesn't take proper care of the child. The reason we do that is because we're protecting something. And we protect something, whether it's one person, whether it's 5 people. I remember a commercial, is one enough or two too many? It dealt with a laxative, I think. But here, every person who takes custody of a child, well, they can even do it for free. If it's a church, it's for free.
Internship.
An internship, well, Your Honor, it's not the case here. Maybe if you get close to 17, it's close. But let me ask you something else. How about not an internship? How about a high school football team? How about a high school football team that takes those football players.
Now we're talking a school. That's a different situation.
Doesn't make a difference who it is, Your Honor.
All right, thank you.
Thank you.
Foad versus Milton Hershey School. You may proceed.
May it please the court, John Crossman for the Elliott Greenleaf defendants. I'm from Zuckerman, Gore, Brandeis, and Crossman. It seems to me it should be inarguable that jurisdiction over a defendant must exist at the time the lawsuit is commenced. I frankly find it hard to believe that I have to make that point, but I'm going to touch lightly on it before moving to my next point. I think the one thing that I picked up from the cases in the briefs that was really kind of like a nice lodestar for that point was a comment in Black v. Drain, which was a Second Circuit decision. At the very end of that decision, the court points out, you can't have fair warning as a defendant that you might be hauled into court in New York if the thing that would warn you hasn't happened yet. And that's all, barring questions, that's all I'm going to say on that point.
So, but essentially, the other side is arguing that because Hatfield occurred in New York, that somehow bootstraps all the defendants into that.
Bootstrap is the exact word that I would go for, Your Honor. Now, we know that there are at least three things you have to show for a so-called co-conspirator, even separate and apart from the timing issue, right? You've got to show there was a benefit to the out-of-state alleged co-conspirators. You've got to show there was knowledge and consent of what was happening, and you've got to show that there was some control over the actor. Now, the benefit, frankly, I've searched the papers. I can't find any benefit. Is it that Hatfield went to this apartment to get a copy of this 1999 memo that's talked about so much? Because if that's the benefit, how did my clients or the other defendants benefit from him getting a copy of that memo, which they had had in their possession for 11 years prior to this lawsuit being commenced? So they had the document, it had been filed in courts, it had been discussed extensively. There was no possible benefit to getting another copy of that memo. So that, I don't think, can be the benefit. Other than that, I don't see any benefit of any kind. But then we get to this issue of knowledge and consent and also the some control, which I think on these facts come a little close together. And here's something that I think it's very important that I make sure the panel is aware of, because there are some statements in the reply brief on appeal by Mr. Foad, which I believe are incorrect. And because we didn't get a chance to respond to them, I want to make sure you noticed that they're not supported. The statements I'm referring to appear first in the Foad reply brief at page 8, or one of the two places it appears, where it talks about how the defendants had awareness of, and this is important, awareness of the effects of Hatfield's stalking at his home. And I want to focus on the word effects. That's effects with an E, right? So he's talking about the effect, the thing that happened as a result of him going to the apartment and going into it. So he is alleging that we learned about the break-in after the break-in. He's talking about the effects of the break-in that we had knowledge of. He doesn't say we had knowledge of the plan to do it or the attempt to do it. He doesn't allege that we told him to do it. He doesn't allege anything like that. So there's no actual allegation of us knowing anything in advance. And this brings me to the part that I think is really important for you to be aware of. At page 2, in footnote number 2, on page 2 of his reply brief again, this is the one we didn't respond to, he says that we don't talk about, quote, Hatfield's phone conversations with defendants during both the attempted and successful New York break-ins. This is all citing R945 of the record. And if you go to R945, it's Foad's affidavit, his sir reply affidavit submitted as supplementation of his proposed second amended complaint. So it's not the second amended complaint, it's not an allegation, it's an affidavit. And then if you look at what he cites in that affidavit, he's citing Exhibit D to that affidavit, and that's on R950. And if you go to that, I should also say at paragraph 58 of the affidavit at 945, which is the page he cites, he says defendants where, I see am I read?
Go ahead, yes. But go ahead. I'm still interested, so keep talking.
Thank you, Your Honor. He says defendants were aware of the New York break-in on real time and acted to cover up the crime by directing Hatfield to destroy evidence and flee the scene. Now, here's what I want you to notice. If you look at Exhibit D, which Foad says at at R941, he said he personally transcribed that page himself from either this Facebook post he's talking about or some YouTube post, which is no longer available, that apparently none of us can access now. But he says Foad himself prepared this transcript. So we can, I think, assume that he wrote down whatever was important to him when he was transcribing it himself. And it does not say anything about any phone call during either break-in or buying an airplane ticket to take him anywhere. There is nothing in the document that his affidavit points to about these alleged things. I want to make sure the panel is aware that there's just no evidence of that. It is not alleged in the complaint, which brings me to the very last thing I want to say, if you will indulge me.
Okay, go ahead.
Your Honor. At R116, paragraph 287, Foad alleges that E.G., that's my clients, repeatedly ratified and adopted the tortious conduct of these individuals. And I just want you to focus for a moment on the words ratified and adopted. Once again, we have language of after-the-fact conduct, not of knowing in advance, not of approving, not of controlling. Thank you for your indulgence.
Okay. Okay.
My colleague here to introduce me.
Okay.
Your Honor, I'd like
Go
to
ahead.
introduce my colleague, Mr. Bilas, and request that he have permission to argue on behalf of the MHS appellants.
It's too late to go through the spiel. Go right ahead. Granted.
Thank you, Your Honor. May it please the court, my name is Alexander Bilas from Saul Ewing. I represent the Milton Hershey School defendants. That includes the school, board members, and several employees and former employees of the school. The court should reverse those portions of the trial court's order that found that there is personal jurisdiction here over the non-New York defendants. I'm going to adopt all of the arguments that my colleague made on that point. I want to go to another couple of reasons why the court should reverse what the trial court did here, specifically on board defendant immunity. These are several individuals who are on the board of this nonprofit school that serves disadvantaged children. There is a statute in Pennsylvania that says that board members, acting in their roles as board members, cannot be sued unless they breach a duty to the corporation, the nonprofit corporation. The trial court below skimmed right past that requirement of the statute, that exception to immunity. And it went right to the second part, which is that not only do they have to have breached a duty to the corporation, but that breach must have been related to self-dealing, willful misconduct, or recklessness. The trial court seized on that second part of this exception to the immunity statute, but it did not address the fact that there was no allegation that they breached a duty to the school itself. And for that reason, they cannot be sued here in their roles acting as board members of this school. So if you find that all of the non-New York defendants should be dismissed for lack of personal jurisdiction, there is one New Yorker in this case, a board member, David Saltzman. He also needs to be dismissed because of this immunity statute. One last point, Your Honor. I know it's very late in the day.
It's okay.
The court, if the court disagrees with us on those 2 points, the trial court also correctly dismissed one of the individual defendants, Andrew Klein, because he had left the employee of the school before Mr. Hatfield broke into Mr. Foad's apartment in December 2020. There are 3 other individual defendants who stopped being affiliated with the school before the break-in, and that would be James Mead, Velma Redmond, and Ralph Carfagno. They're in the record, and I've cited in our briefs. You will find at their affidavits in support of our motion to dismiss for lack of jurisdiction, explaining when they stopped being affiliated with the school. So if the court agrees with the trial court's decision that Mr. Klein should be out, these 3 people should also be out for this additional reason.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. May it please the court. My name is Michael Wilner. I, too, am from the Commonwealth of Pennsylvania and have been admitted pro hoc vice. Do I need my supporting counsel
granted.
to introduce me?
It's granted.
Thank you.
Okay, go
Thank you,
ahead.
much appreciated. In this case, we allege an unprecedented IID campaign that began decades ago in around 2002, 2003. It goes, New York law is some of the most developed law on IID campaigns, malicious and deliberate campaigns of harassment. We allege as part of that IID campaign, there was abusive process and intentional interference with contract that were integrated in that campaign. Part of the error below was failing to recognize that those were independently actionable on one hand, but whether or not they were independently actionable, the same conduct supported our claim for IID. And because that conduct had occurred before the filing of this case, the summons with notice in New York, there were abundant jurisdictional facts of physical acts in New York that were part of the IID campaign that gave this court jurisdiction long before Nevada Hatfield, as part of the IID campaign, came to New York, stalked the plaintiff, twice broke into his building, once in November of 2020 and once in December of 2020. The second time, the first time the police arrested him at the door before he could break it down, the first time, and the second time he broke the door down, was in there for quite a while, and did defendant's bidding. He has
That was a long time after this lawsuit was commenced, correct?
I'm sorry, Your Honor?
That was a long time after this lawsuit was commenced.
It was indeed. It was indeed.
And are you asserting that as a basis for jurisdiction?
Well, we've asserted abundant acts beginning,
Are you asserting
including
that as a basis for jurisdiction over the non-New York defendants?
well, what happened is the trial court seized on that act, both to establish sufficient outrageousness of the ID campaign and for personal jurisdiction, because the things that Nevada Hatfield did when he broke in were things he was singing their song from their songbook that he was taught as part of his agreement with them, which is documented in the record.
Could you answer my question? Are you relying on those events in 2020 as a basis for jurisdiction over the non-New York defendants?
We are not relying on that independent of the overall record, but under the single act requirement, I think that there is a strong argument to me that that alone would be sufficient. But we show a plethora of acts in New York, physical acts in New York in 2015, a quarterly board meeting at which we plead in paragraph 5 of the Second Amendment complaint, this ID campaign required funding of millions of dollars. And every board meeting, it implicitly adopted, ratified it, and approved that funding. Plaintiff, before Nevada Hatfield broke into his home, into his building twice in 2020, and then into his apartment in December in the second visit, plaintiff had written a letter, an open letter that defendants knew about, saying, what you're doing with him is dangerous to me. In our complaint and in the record in this case, Nevada Hatfield wasn't the first person that they incited with their IED campaign to come to New York and stalk and harass plaintiff. Another individual in 2005 came to New York, broke through building security, and threatened plaintiff. They were aware of the risk of Nevada Hatfield. And the council mentioned the record of Nevada Hatfield's Facebook posts, and those were in 2022. Plaintiff's affidavit says that our citation on the record is a verbatim of what was posted on Facebook. We are not responsible at this level. We haven't gotten discovery to be able to go get more about it, but it is entitled to be credited as true. And in that affidavit, there are extraordinary admissions as a co-conspirator, which the Supreme Court properly found this was an IED tortious conspiracy, of the control that they're now protesting. Hatfield admits that on MHS and EG's insistence, and EG as his handlers on behalf of MHS, with the awareness of the MHS president and the MHS board, okay, that he was directed to evade service of process and did so when we were trying to serve him with the First Amendment complaint, that they told him to move. He moved from West Virginia to Florida, that they told him to destroy evidence, that they told him to lie, that they told him to, they were deceiving the courts as to his evasion of the process. So the record here shows extraordinary control of Hatfield, including suborning perjury. While I understand that these things seem extraordinary,
That light has been on for quite a bit, and I have given you quite some time, so I need you to wrap this up.
thank you. I just want to address the basis why.
And that doesn't mean another 2 minutes. That means another 30
I'll be
seconds.
as quick as I can.
okay?
Thank you, Your Honor. I appreciate the indulgence. When you look at the CPLR and its liberal requirement for supplementing a complaint, unlike 99.9% of cases that relate to acts that already occurred, we pleaded ongoing tortious conduct, which in specific jurisdiction, the plain language of 302A, I'm talking about subsection 2, but A says, if it arises out of acts, when you have an ongoing tortious act, where you have an IED campaign that at some point might become actionable, and courts may disagree about that, what do we have to do? File another complaint after that happens, saying, and then move to consolidate them? It makes no sense to say that when you plead an ongoing tortious campaign, and as the Howell case, the Court of Appeals Howell case recognizes, IIED can be conduct that looks lawful, but because it's part of an IED campaign, it's not lawful. So as plaintiffs, we had a case on file
Right,
years
you're
after
going to
this
have a
campaign
minute on
started.
rebuttal, counsel. That's
Thank
it.
you.
Each of you have 1 minute left, and I'm holding you to your minute.
I won't use my whole minute.
Okay,
First of
because
all,
these poor gentlemen back here are waiting.
everything counsel just referred to about directions to evade service of process, I'm not going to touch whether that's true or not, but it all happened allegedly in Pennsylvania, not New York. The other thing I want to say is look at Foad's reply brief again at page 2, note 1 this time, where he talks about facts warranting an inference of conspiratorial conduct at the pleading stage include joint activities and meetings, conferences, and telephone calls. The kind of thing that every board in America does every day. That can't possibly be enough to make them all conspiracies. Thank you.
Thank you. Counsel, you have a minute.
My colleague hit the point about meetings and emails and phone calls. That's what Mr. Foad has alleged here. That cannot be enough to establish jurisdiction over these defendants in New York. The trial court focused on the break-in because that is a break-in is a tortious act. Now, we've already covered why Mr. Hatfield was not acting as our agent when that happened. He was a rogue actor. But everything that happened before that clearly did not establish jurisdiction in New York. So you can't bring in all that prior activity. And you had to have jurisdiction at the time the case was filed, and they didn't.
Thank you.
Thank you, Your Honor.
You have 1 minute.
Thank you, Your Honor. The record at R944962 reflects the averment that Hatfield broke into plaintiff's home and admitted that it was, quote, to assist MHS. What Hatfield did when he broke into that home was get out a copy of the misappropriated 1999 memo that was underlying their abusive process and their disparagement of plaintiff. They misappropriated that and used it expansively in courts, including Southern District of New York courts and Supreme Court below. They quoted it. Those were all tortious conduct well before this filing. Not only that, when Hatfield broke in, he rifled through our plaintiff's confidential files, got out the original 1990 memo that these parties had moved for in discovery. We put it on a discovery log. They have filed the motion to compel. So they were seeking the original. Counsel made an argument to you that what interest did they have? Why were they asking for it in discovery? We offered to offer it in camera to the court, and that's where it was pending when the case got sent here. Hatfield believed, he knew how important that memo was to them. He believed he was acting on their behalf. Thank you.
Thank you. And last but not least, ARCPE 1 versus Public Service Mutual. You may proceed, sir.
Good afternoon, Your Honors. My name is Thomas Curran. I represent the appellant ARCPE 1. This matter should not have moved forward in the court below. The untimely filing of the motion for summary judgment should have been rejected by the court below. The court used an inappropriate legal standard when allowing the consideration of this admittedly late filed summary judgment motion. The court did not even engage in the analysis that this court and the Court of Appeals requires for these late filed summary judgment motions, and that is the good cause for delay analysis. Court didn't do that analysis. Court rejected that requirement, and had she done so, she would have found that in this case, there was no good cause. This was perfunctory law firm failure. There was...
Why don't you get to the merits if we...
I'm sorry.
Address the merits of the issue. Assuming we get past the issue you've been talking about, why don't you address the merits of the issue?
The merits of the underlying summary judgment motion.
Yes.
There were two aspects of the policy that the insurance company had to demonstrate in order to...
Were the premises vacant for more than 60 consecutive days?
Yes, that's absolutely true, Your Honor, and therefore...
So water damage would be excluded, wouldn't it?
Not all water damage.
I'm not talking about sprinkler leakage, but water damage.
Some of the water damage.
Like from the domestic lines in the kitchen and bathroom.
Yes, and the vast majority of what happened...
The sprinkler damage.
Was sprinkler damage, and the provision there in that is that the sprinkler leakage, unless you have provided protection, protect the system against freezing. That doesn't mean...
Didn't they have a dry sprinkler system, which one could argue, couldn't they, that in and of itself was a method to attempt to minimize any potential damage?
Yes, that's one of the main 2 points that we make, is that a dry system is in and of itself a protection against freezing because that's what it's used for. And our expert, who the lower court seemed to just disregard, goes into detail on that fact that these are used in garages, they're used in places where the open air generally will get at the pipes, so they use these dry systems. In addition to that, our predecessor, the Carmen Anthony Restaurant Group, actually had an electronic heater stationed right near where the sprinkler system was to protect against that. So there was protection against that.
And that the expert, that there was 46 degrees inside, which meant that there must have been some heat being provided.
That's exactly
All of that you would say creates an issue of fact.
Right. Whether or not they did their best to maintain the heat is an issue of fact that must go to the jury. And there's certainly plenty of evidence of that, in that on a frigid day, the testimony from Ms. Murdoch was it was frigid outside, but it was warm in the building, and she looked at the thermostats and they were showing 46 or 49, she can't remember, but it was one of those two degrees out. Moreover, this issue of looking at the heat, the natural gas coming into the building, and there's two particular pieces of evidence. One is the meter, the gas meter, which between November 20th and January 14th, so right, the loss was right in the middle of that. The gas meter showed that there were 278 cc's of natural gas. That's 27,800 cubic feet of natural gas going into the building.
Okay, you'll have time on rebuttal, okay?
Thank you.
May it please the court, Kevin Buckley on behalf of Respondent Public Service Mutual. As Justice Freeman pointed out, with the vacancy provision, it bars coverage for water damage. So that part of the claim is barred and there's no exception. With regard to the other part of the claim, the sprinkler damage, under the same vacancy provision, it also bars damage caused by sprinkler leakage. We've established that the building was vacant for 60 days and there was some damage from sprinkler leakage. Therefore, that exclusion is triggered and the burden shifts to the insured to prove that it meets the exception to that exclusion.
So why isn't there an issue of fact on that particular question in light of the presence of the electronic heater near the system and the use of this dry system that they had in place?
Yes, Your Honor, good points. The presence of, as we all know, this was an abandoned building. They closed down, ceased operations, and walked away from it. We asked for the testimony of the representative of the...
Well, I wouldn't call it abandoned if they're still heating it even portion,
Well,
right? So, I mean, it's shut down, clearly. They weren't operating a business in it.
shut down,
Right,
and for
right.
the last
Yeah.
2 months before the last two heating cycles, there was zero, or essentially zero, gas used, and gas was how they maintained heat in this building. So what we're talking about here is you asked the question about the dry system, and I want to get to your question, because I understand what happens if I don't. So it is similar to saying, well, we had a boiler, and that's how we protected the sprinklers from heating. There was a boiler. No one checked whether gas was coming in. No one checked the temperature, but we had a boiler. They installed it 50 years ago. That should be good enough. No one installed this system in the last year. There's been no testimony from anyone that says they checked this system, it was operating. Our expert had said he looked at the system and it could have been turned off is the reason why, to save electricity. No one knows because they haven't produced anyone, when we've asked numerous times, anyone who who could come in and say, yeah, I went to the building 5 times before the loss. I knew it was going to be freezing, single-digit temperatures, so I went and checked to make sure the heat was on. I made sure that there was air in the dry system, which there was not. There is absolutely nothing in the record from anyone with firsthand knowledge who can say, I did this to protect the building from freezing, to protect these pipes from freezing.
Who has the burden on that?
The insured has the burden. As I said, we established the exclusion, and I believe it's in the appellant's brief as well. We agree on this law. We established the exclusion, 60 days, buildings abandoned and damaged by leaking sprinkler. Now they have the burden of establishing the exception to the exclusion. And they haven't done that because they haven't brought anyone in to show that they did anything.
Well, they have the burden to do that at trial, but at the summary judgment stage, they have the burden to raise triable issues of fact.
Right, and I don't believe they've raised triable issues of fact because there's been no admissible evidence contrary to what has been established here is that the exclusion is triggered.
But you say they have the burden, but on the motion for summary judgment, who has the burden?
On the motion for summary judgment, we have the burden of proof, and we've satisfied that burden by proving the exclusion. And now I believe it's their burden to come back.
The vacancy exclusion would not be triggered if they adequately took care of avoiding the pipes from the sprinkler system from freezing, correct?
If they protected, right.
And we have information on this record that suggests that someone was setting up a heater to keep the pipes warm. But moreover, your own expert could not explain how water got into the dry pipe system, correct?
Correct. He pointed out 3 things that could have caused it. One was someone turned off the system. Another wasn't maintained. I mean, and just to your point, Your Honor, you mentioned the heater. Again, there's been no person with firsthand knowledge to talk about the heater, when it was put in, when it was turned on. Why was it turned on if there was heat in the building? Was it turned on the day of the loss?
Thank you.
That's my issue. Thank you.
You have 1 minute.
Thank you, Your Honor. We don't agree, as my brother had indicated, that all they have to do is demonstrate that there is an exclusion. No, under the Stevenson doctrine, which we cite in our briefs, they must prove, their burden is to prove that the exemptions under the exclusions that they claim are valid. In other words, the entire exclusion. So in this particular case, the exclusion says that they won't pay for loss for if the building is vacant for more than 60 days for sprinkler leakage unless you have protected the system against freezing. They have the burden on the entire exclusion if they're going to claim the exclusion. With regard to what evidence is there, no matter what you look at on the gas coming into the building, there's only one mechanical unit that's using gas as its source, as its feeding source, and that is the heating system. So there is gas going into the building. It's demonstrative. Is it as high as it was when it was operating the business? No, but it doesn't have to be. But where is the gas going? A reasonable inference is the gas is being used by the heating system. We know it's not leaking out into the building because the building didn't explode. So just the dint of the fact that there's gas going into the building during the period of time where the loss was, okay, and then you have the professionals who, there's evidence in the record that the professionals were both inspecting and repairing the heating system and the sprinkler system.
Thank you.